Clause 2, the chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. The chair now recognizes the gentleman from Ohio, Mr. Rulli, to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we begin our business today, I want to welcome our newest member of our committee, Mr. Garcia. Glad to have you. First elected in 2018, he's represented Illinois' 4th Congressional District here in the House for the past 3 years. And prior to coming to Congress, represented the Chicago area in several elected offices, including the Chicago City Council, Cook County Board of Commissioners, and in the Illinois Senate. And Mr. Garcia, welcome to the Judiciary Committee. And I now recognize the ranking member for comments.
Thank you, Mr. Chairman. It's my pleasure to welcome Representative Chuy Garcia to the Judiciary Committee. Currently serving in his 3rd term, Congressman Garcia represents the 4th District of Illinois, encompassing parts of Chicago and its surrounding suburbs. His seat was previously held by Luis Gutierrez, a distinguished former member of this committee. Congressman Garcia was born in Los Pinos, a small village in Mexico, and immigrated with his family to Chicago when he was 10. As a young man in Chicago, he joined local organizing movements for workers' rights and community empowerment. From there, he began a long career in public service, holding such positions as committeeman of the Cook County Democratic Party, Chicago City Council member, Illinois State Senator, and member of the Cook County Board of Commissioners. Since his election to Congress, he has quickly established himself as a leading progressive voice on many issues, including immigration. And I'm pleased that he will add his voice to our debates in this committee. I ask my colleagues to welcome Congressman Garcia, and I yield back. Mr. Chairman.
Gentlemen, the ranking member is recognized.
I have one other quick point of personal privilege. It's come to my attention that my Chief of Staff, John Doty, began working in my office on this day exactly 30 years ago.
Wow.
Rising from an intern to the Chief of Staff and holding nearly every job in between, he has played a critical role in virtually every issue that has come across my desk over these last 3 decades. I'm grateful that he continues to be at my side each day, and I look forward to his continued service to my district and to this committee. Thank you, and I yield back.
Thank you for that. That's special. Our first order of business today is approving a new subcommittee roster. This roster was distributed to members along with the notice for today's markup and assigns Mr. Rulli and Mr. Garcia to subcommittees. Specifically, Mr. Rulli is assigned to the Administrative, State, and Immigration subcommittees. Mr. Garcia is assigned to the Crime and Immigration subcommittees. Finally, the roster officially appoints Ms. McBath as the ranking member of the Crime Subcommittee. Congratulations to the gentlelady from Georgia. I ask unanimous consent that the committee approve the appointments and assignments as reflected in this roster. Without objection, the subcommittee roster is approved. Pursuant to notice, I call up H.R. 8205, the Keeping Violent Offenders Off Our Streets Act, for purpose of a markup. Move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 8205.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Chairman. The use of crowdsourcing for posting bail has long been scrutinized by courts as a way to disguise the true source of funds. Crowdsourcing for bail has been seen, at least to one scholar, as, quote, an easy way to legitimize money, which would have otherwise been rejected by the court due to its likely being the proceeds of criminal activity. That's because if there is little or no relationship between the defendant and those supplying the money, the bail money provides no incentive to prevent the defendant from simply fleeing the jurisdiction. This is especially true if the money does not have to be paid back. But while crowdsourcing funds is generally illegal, the use of charitable bail funds remains legal in most states. Charitable bail funds generally flew under the radar until 2020, when the George Floyd riots caused revenues to balloon, thanks to solicitations from celebrities and politicians, including then Senator Kamala Harris. What used to be small, community-based organizations that helped post bail for nonviolent misdemeanors has now grown into a multi-million-dollar industry. For example, the Minnesota Freedom Fund saw revenues increase by 18,000% between 2019 and 2020. Similarly, the Bail Project saw its contributions triple in 2020 to nearly $42 million. These funds are nearly indistinguishable from crowdsourcing websites. There's no relationship to the defendant. The donations come with little to no scrutiny, and there is no guarantee that the money would have to be paid back. Perhaps more alarming, what was intended to help bail out low-level, nonviolent protesters has instead been used to release violent felony offenders back into the streets with little to no oversight. In 2021, for example, the Minnesota Freedom Fund, which then Senator Harris actively promoted, released a domestic abuser back onto the street. 2 weeks later, that man, George Howard, was charged with second-degree murder for a road rage incident. Michael DeWitt of Louisville, Kentucky, was bailed out by a bail project in February of 2021 after being arrested on multiple charges. 2 months later, he was arrested for murder. Sean Michael Tillman, 3 weeks after having his bail paid by the Minnesota Freedom Fund, murdered a man at a light rail station in St. Paul and is now serving a life sentence for that crime. Mr. Chairman, the list goes on and on. According to an investigation conducted by CNN in Hennepin County, Minnesota, the Minnesota Freedom Fund has bailed out at least 65 defendants who are awaiting trial on felony charges involving violence, physical threats, or sex crimes. Similarly, in Indiana, of the roughly 1,000 defendants released on bail supplied by the Bail Project between 2019 and 2021, 24% had previously been charged with a crime of violence, and 35% were accused of felony charges and had a previous charge of at least one crime of violence. And because these funds are crowdsourced, there's no incentive for the defendant to show up for their court date, and many of them don't. According again to CNN, nearly 42% of roughly 500 defendants bailed out by the Minnesota Freedom Fund later failed to appear at one or more court hearings between 2001 and 2022. Commercial bail companies, by comparison, had a failure to appear rate of only 22% during that same period of time. This is why many states have begun regulating the use of charitable bail funds. Georgia, for example, limits the amount of cash bonds a charitable bail fund can pay in a given year. Indiana prohibits the use of charitable bail funds from posting bail for violent and felony offenders. Unfortunately, state-by-state patchwork probably will not solve this problem. That's why we're introducing the Keep Violent Offenders Off the Streets Act. The bill makes a small but important change to our criminal code to define bail bonds as an insurance product, thereby subjecting them to the same federal background check and regulatory requirement as those of for-profit bail agencies under the Federal Comprehensive Crime Control Act of 1994. This change would also bring charitable bail funds under a state insurance regulation, giving states the ability to better scrutinize the use of these funds. Let me be clear, this bill does not outlaw the use of charitable bail funds, nor does it regulate the posting of cash bail by family and friends of the accused. This bill merely says if you are operating as a non-for-profit with the purpose of posting cash bail, you should be subject to the same regulation and oversight requirements as those operating as a for-profit entity. This will bring needed oversight to organizations that for years have gone unregulated while ensuring accountability of these funds by subjecting them to federal insurance fraud statutes if they misappropriate funds or misrepresent the use of these funds in any financial report. The bill is a step forward in reversing kind of the radical, what we know now are kind of left-wing bail policies like those that were promoted in Minnesota. I urge my colleagues to support H.R. 8205, and I yield the balance of my time.
Gentleman yields back. Chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 8205 is yet another vehicle for Republican campaign messaging that does nothing to help the American people. This bill, which would amend the federal insurance fraud statute to define, quote, the business of insurance, unquote, to include the posting of any kind of monetary bail does nothing to address violent crime. It is simply another attempt by Republicans to claim that Democrats are soft on crime and to distract the American people from the indisputable fact that crime is down across the country, and it has been for several years. Instead of leaving state interests to the states, this bill appears to target nonprofit bail funds that try to address the clear inequities that result when people without financial means are held pending trial, simply because they cannot afford to pay the bail amounts set by the court. Nonprofit bail funds, the Minnesota Freedom Fund in particular, have become a target of Republicans recently as they desperately tried to prop up their failing presidential candidate by attacking Vice President Harris and Governor Walz. Former President Trump has repeatedly and falsely claimed that Vice President Harris donated to the Minnesota Freedom Fund and that her donation secured the release of a man who went on to commit murder. This is nothing more than another made-up story the Republican ticket has created, and it is just as false as the former president's claim that immigrants are eating the dogs. The Minnesota Freedom Fund has confirmed that Vice President Harris has never donated to them, and that her only relationship to the fund was a 2020 tweet encouraging people to, quote, chip in if they were able, 2 years before the result of the release of the individual who committed the murder that Republicans basically blame on Vice President Harris. And while the bill's sponsor claims that weak bail policies led to a tragic incident in Waukesha, Wisconsin, we know that the person's release in that case was not due to bail reform or any specific policy. Instead, it was the result of a mistake made by an inexperienced and overburdened assistant district attorney who erroneously asked for a bail amount, far below what her office's policies required at the time. Of course, this does not make the Waukesha murders any less tragic, but it demonstrates that Republicans are willing to politicize even the most heinous crimes to serve their desperate needs. We know from experience and from actual data that when you put the political rhetoric aside, Democratic policies work to reduce crime. Homicides are down across the country. Violent crimes are down. Property crimes are down. We learned just yesterday that even drug overdoses are down this year, substantially. And while my Republican colleagues love to criticize policies aimed at eliminating or reducing our justice system's reliance on cash bail, study after study, including a recent comprehensive study by the Brennan Center of 36 jurisdictions, shows that bail reform has not led to an increase in crime. The underlying premise of this bill, that bail policies have increased violent crime, is fatally flawed. But that is not the only problem with this legislation. Another problem is that the insurance fraud statute that this bill seeks to amend applies only to, quote, the business of insurance, unquote, that affects interstate commerce, which the posting of bail by a state or local bail fund does not do. The bill also applies to entities that post any bond, including non-criminal immigration bonds, which has nothing to do with violent crime. In fact, the provisions of this bill that actually attempted to address violent crime by allowing state and local jurisdictions to use burn-jag grants to develop public safety reports relating to each defendant charged with a violent offense has been stripped from the bill by the ANS. All that remains is the provision relating to insurance fraud. I challenge my Republican colleagues to explain how exactly subjecting state and local bail organizations to federal insurance regulations and federal criminal penalties will reduce violent crime, when the vast majority of the bonds they post are for nonviolent crime, and when these organizations are already regulated by their own states. I expect my Republican colleagues instead to spend their time this morning citing individual examples of people who committed violent offenses after being bailed out by nonprofit bail funds. Each is tragic, and our hearts go out to the victims and their families. But they won't tell you about the thousands more who received help from these funds, finished their cases, and moved on with their lives without incident. They won't tell you about people who commit crimes after being released with the help of commercial bail agents. And they will not tell you that it is a judge, not a bail fund, who decides whether to set cash bail in a given case, and if so, in what amount. Bail funds simply allow indigent defendants to obtain a release that a court has already deemed to be appropriate. We must remember that we cannot ask for or expect perfection from our bail system. What we can do is to make sure that the solutions we propose for violent crime are actually targeted to address the problem rather than to provide sound bites for social media. There is no question that we must address the root causes of violent crime, invest in proven solutions, such as community violence intervention and drug treatment, and we must also support law enforcement with funding and other resources rather than attacking the FBI, ATF, and our other federal partners relentlessly. Furthermore, if we are going to subject state and local bail organizations to federal regulation, we must do so only after a hearing to explore whether increased federal regulation of bail as insurance will advance our shared goal of keeping Americans safe. If and when the majority decides to get serious about combating violence in America, I will gladly join them in exploring serious solutions. But this legislation is no solution at all. Therefore, I urge my colleagues to join me in voting no on H.R. 8205. Thank you, and I yield back.
Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Wisconsin for the purpose of offering an amendment in the nature of a substitute.
Yeah, Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R.
Without
8205.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text. For the purposes of amendment, the chair recognizes the gentleman from Wisconsin to explain the amendment.
Yeah, Chairman, this amendment strikes Section 2 of the bill. The amendment makes the bill more straightforward to ensure that corporate, nonprofit, and for-profit entities posting bail on behalf of someone else are subject to the same federal insurance laws that I spoke about earlier, and I would urge support for the amendment. Yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I want to ask my colleague from Wisconsin some questions about what this legislation actually does with respect on two fronts. One is that at the federal level, the Bail Reform Act, which has been in place for 40 years now and withstood varieties of constitutional and judicial challenges, that governs bail at the federal level to the extent they still use it, because the act was aimed at avoiding cash bail and putting in place a series of other types of methods to ensure that a defendant would return to court. So I assume that this is not aimed at touching on federal bail. Is that fair?
No, it's simply, it just adds that federal crime statute dealing with the insurance-related crimes.
Okay. So then looking at 1033, which is the statute that you amend with your amendment here, your proposed amendment, you're amending a section where it defines the business of insurance. And in that definition that's related, it says the term insurer means any entity, the business activity of which is the writing of insurance or the reinsuring of risk, and includes any person who acts as or is an officer, director, agent, or employee of that business. Under your amendment, who would be the insurer?
At the time that we were writing the bill, I think what you could say is that there probably would be many different variations of whatever that insurance product could look like. So, you know, what I'm trying to do is that this would prohibit them, for example, from making kind of material false statements on any financial report. Maybe there's a misappropriations of these funds once the crowdsource is completed, or maybe misrepresenting the use of the funds.
Okay, but if we're gonna,
So if you got an insurance product, I think it could be it could
okay,
vary. It could
okay,
vary.
but if we're gonna expose somebody to criminal liability, the statute, I think, needs to be very clear on who exactly would be facing criminal liability in the event that you think fraud takes place. So who would be exposed to criminal liability under your amendment?
Well, the presumption is not necessarily that there's anything wrong with the crowdsource. It would simply be that now, once again, there's some oversight over what that pot of money is doing, how it's functioning, and what it looks like.
This isn't
which
an
is the problem
oversight
we're trying to
statute.
get
This is a criminal liability statute. This isn't just oversight. And by the way, since this isn't aimed at federal bail, wouldn't the state insurance agencies be the ones who should be regulating a state bail bond determination under your logic?
No, I mean, I think that what we're expecting is that the type of oversight would be similar, but...
Similar to what?
Well, from state to state. And that you would have a situation where if you had one source of oversight over these funds, that it may change. It may be different in Wisconsin than it would be in Maryland.
Okay, well, look, just let me be clear about this then, based on what I think you're saying. State to state, this is going to have a different impact because some are going to have state insurance, corporations, and some are not. State to state, you're going to have judges who would be making bail decisions, who I think would be immune from being held criminally liable for a determination that they might make about whether bail should be granted. So certainly the judge can't be viewed as the insurer. And based on what I think you just said, we don't know who would be subject to criminal liability under your amendment to this provision, which I think is, to say the least, a very dangerous way to move forward. And I think when you have a criminal provision that's that vague, as we saw when McDonnell decision from the Supreme Court, if it's vague and it's criminal, it's inherently unconstitutional because you're not giving people who could be subject to criminal exposure the notice that they deserve before they commit any kind of act. I'm running out of time. I had other questions about interstate commerce issues as well, because the provision you're amending focuses on interstate commerce as opposed to intrastate commerce. So even if we assume this is commerce-driven, you're trying to regulate something that by definition is intrastate, and therefore I think would not be covered by the provision of 1033. But I've exhausted my time, but given the answers we just got, I think I'm compelled to vote against the amendment as it stands.
Gentleman yields back. Who seeks recognition? Gentleman from Arizona, Mr. Biggs, is recognized.
Thank you, Mr. Chairman. I don't want to engage in that debate because I've got other stuff I want to do, but it just seems to me that the bail fund that commits fraud would be the culpable party criminally, just like we hold corporations and other institutions who commit fraud liable criminally. Leave that for a second and just say when you're concerned about interstate fraud, the particular organization that we're talking about, Interstate Commerce Clause, was receiving money from all over the country. So they could be engaged in fraud that touches that, so perhaps that might assuage you, maybe not. But I would just point out that the ranking member always, and I hear this often, they refer to the FBI data and say, crime is down. Don't believe your lying eyes. But here's the deal. The data for FBI changed the way they gather data. And now you have 40% of states, cities, and localities that don't even report. Then you have another 20% that only report part of it. So your data is bad. And when I talk about not reporting, we're talking places like New York City doesn't report. California doesn't report. So how can you even begin to say you've got accurate data? You don't. So let's go ahead and let's review a little bit of the Minnesota fund that we're talking about largely today.
If you were stuck in jail, who would come to bail you out? A Minnesota nonprofit has $35 million at its disposal to do just that.
It may just be the closest thing to a get-out-of-jail-free card. Jaleel Stallings, charged with attempted murder, prosecutors say he shot at a SWAT team during the riots in May. Someone paid $75,000 cash to get him out of jail. All three would probably still be sitting in jail if it wasn't for the Minnesota Freedom Fund, the group that paid their bail, no questions asked.
Last time I was down there, they said, we hate it when you bail out these sex offenders, was exactly what they said. And
Greg Lewin is the group's executive director, who says it's not about the crime, it's about the system.
I often don't even look at a charge specifics when I bail someone out. I'll see it after I pay the bail because it's not the point. It's just that it is not the point. The point is the system that we're fighting.
And now the Freedom Fund has a whole lot more money for that fight. Prior tax returns show in a good year they pull in about $100,000 in donations. But after the police killing of George Floyd and supportive tweets from Hollywood celebrities, they've now received more than $35 million in contributions.
As riots shook cities across the United States in 2020, then Senator Kamala Harris authored a little-known blog post urging the public to help demonstrators by donating to a bail fund. Harris is still fundraising on behalf of the controversial charity, according to Act Blue. Harris wrote in the blog post, quote, "I stand with those protesting George Floyd's murder." She then asked people to make a contribution to the Minnesota Freedom Fund. Harris, in June 2020, famously posted a tweet asking people to chip into the Freedom Fund. Since then, the bail fund has freed George Howard, who pleaded guilty to second-degree murder for shooting and killing a man in 2020 in Minneapolis. Sean Tillman of St. Paul, who was sentenced to life in prison this year for first- and second-degree murder. Others who were freed in connection to the bail fund include Darnica Floyd, who was sentenced to prison in 2021 for stabbing a man to death, and a slew of serial domestic abusers. The fund also paid $350,000 to release a twice-convicted rapist, Christopher Boswell.
As a senator, as a politician, someone who has to respond to the constituents, what do these protests mean to the ability to affect change legislatively? Because
the only way we're going to truly achieve change is when there are people in the system who are willing or pushing to do it, and when there are those folks who are outside of the system demanding it. I am very clear that some of the success that we've been able to achieve around criminal justice reform would not have happened in recent years were it not for Black Lives Matter. And the intensity and the brilliance of that movement that forced at least that there would be some counterforce to the status quo, which is so reluctant for change, if not hostile to change. That's what these movements do. That where these systems are so invested and ingrained in what they call tradition, but is status quo, often which can be wrong-headed, these movements provide a counterforce to get us to where we need to be.
So when the current vice president solicited funds for that fund, she talked about freeing protesters. But you heard the director say, we don't even care what the charges are. We don't care what the charges are. It had nothing to do with protests. That might be fraud. Yield back.
Gentleman yields back. Who seeks recognition? Gentlelady from Georgia, Ms. McBath, is recognized.
Thank you, Mr. Chair. I just really believe that H.R. 8205, despite what we've just seen on the video, is still a troubling bill because it will magnify the wealth and the opportunity gap that is continuing to plague our country. If enacted, this bill will prevent people who are innocent until proven guilty, who are also deemed not a flight risk or risk to their community as determined by a judge, people that are innocent from going home as they prepare for a life-altering trial, all because they simply cannot afford to pay their bail. People can be forced to wait for months or even years while they wait trial. Under this bill, the difference between waiting at home or in a prison cell would depend simply on their income. In what world is that just? There are bail funds in place that have a stellar record in helping people who this bill would subject to criminal penalties for fraud and for hiring certain individuals involved in the criminal justice system. This country's reliance on cash bail systems has been used to disproportionately affect lower-income individuals and Black men who face, on average, bail rates that are 35 times higher than others. And this country should be moving forward. We shouldn't be moving backwards. These nonprofits, which anyone voting yes on this bill aims to tear down, are helping our constituents nationwide and statewide. Nonprofit bail funds are working to bridge the very gap that this bill aims to widen. If my colleagues across the aisle truly wanted to address violent crime, they would pass legislation that actually keeps Americans safe, such as banning assault weapons, establishing a federal extreme risk protection order infrastructure, or instead of cutting the law enforcement budget, they could vote to invest adequate funding levels to law enforcement. They could even consider investing in community violence intervention programs and other evidence-based programs that work to prevent all forms of violence. I know what it means to keep violent offenders off of our streets. After my son was murdered by a man with a gun, I endured 2 trials to make sure that my son received justice. Keeping violent offenders off our streets means investing in our communities, investing in law enforcement, and bridging the gap between incomes, not treating people differently based upon the size of their wallets. And I urge all of my colleagues here today to vote no on this bill, and I yield back.
Gentlelady yields back. I recognize myself for 5 minutes and yield to the gentleman from Arizona, Mr. Biggs.
Thank you, Mr. Chairman. I'd like to ask if the gentleman from Wisconsin would answer a couple questions for me.
Yes, sir.
So as the bill sponsor, I want to make sure and see if this is accurate. This bill does not prohibit, proscribe, ban, outlaw charitable bail funds.
That's right.
It is a regulatory bill, isn't that true?
Absolutely.
Requires disclosure of information for some of these funds. Is that fair to say?
Right, and it's similar to what some states would require right now.
Thank you. With that, I have no more questions.
I'll take the rest of the time, then, and I'll ask questions as well. So if someone's opposed to this, their opposition would have to be to the charitable bail fund receiving any scrutiny. Is that right?
Yeah, I mean, I think, what we're simply trying to do is make sure that there is some type of oversight. And
would the gentleman yield for a question?
Not yet. Mr. Ivy's comments about interstate issues, many of these funds now obviously have become national funds where there is monies coming in from all over the United States into one particular fund. So I totally understand the idea that maybe in the past when some of these charities existed and they were smaller and localized and not receiving dollars from across the entire nation, that maybe we didn't have the same level of concern, I think, that we have now. But it's just, it's changed. The dynamic of probably social media and the ability to get the word out on some of these funds has changed that dynamic, and there's simply no oversight at all, which I think eventually would cause even more concern at the state level.
So I can see the reason for all the opposition. If you want massive resources accumulated into these charitable funds and then devoted to the purpose of getting criminals out of jail and subjecting the community to their presence, even though they may be risky, even though experience indicates that they've gotten out and killed people. The vice president went out and solicited money for the Minnesota Freedom Fund, and then people were released and killed somebody. And it's always amazing. What is fascinating to me about Democrat policy arguments, whether it's this or on the border, is they take dramatic action to change the status quo, beating their chest about their fairness and their humanity. They produce results, like consider the border security situation. They produce results that have never been seen in history, that put people in jeopardy, cause them to lose their lives, cause them to suffer violent crimes. And when you go do the slightest adjustment to try to even apply some scrutiny to the matter, they build a phalanx, circle the wagons, and deny responsibility for the results that they've caused. I mean, even the notion that in Washington, D.C., where you've seen this massive increase in carjackings and just shocking events all the time, and you're still seeing the lurid headlines. Same thing is true in city of Charlotte, city of Raleigh, where you've seen another 36% increase in homicides in the first 6 months of this year in Charlotte, another 75% increase in homicides in Raleigh. And the only thing that they can do is absolve themselves of any responsibility for the consequences they've caused. I compliment the bill sponsor on a sensible bill to bring this new phenomenon, at least under some scrutiny. And yes, if someone then evades the scrutiny, there'd be a penalty associated with that. All that makes sense to me, too. I thank the gentleman from Wisconsin, and I yield the balance of my time. Now, who seeks recognition? Gentleman from Tennessee, Mr. Cohen, is recognized.
Thank you. Firstly, I heard something, I think, from Mr. Biggs complaining about Ms. Harris giving money to a fund to get some people out of jail. Tell me what you said then, please.
She solicited funds.
Okay, the same difference. It's not the issue. So she solicited funds.
Not the same difference. It's very different than me donating and me soliciting broadly around the country.
Mr. Biggs says that Ms. Harris solicited funds to get these people out of jail and that some of them had done X, Y, or Z, and he thinks this is a big deal. That's nothing compared to a person running for president that says if he's elected, he is going to give commutations and let all the people who have been convicted of crimes of trying to overthrow this government by January the 6th and let them all out of jail. People who beat up cops, people who might have something to do with killing cops, hit them over the head with fire extinguishers, convicted by the jury or their peers, or pled guilty. And he's going to release every single one of them without a hearing, without any new evidence, without anything, just politics that he thinks it makes him look good to his enraged conspiracy crowd that thinks there's something going on. He's going to let all these people out of jail and let them out, and that's pales in comparison to anything Ms. Harris could have. But soliciting funds, that's one thing. Declaring total amnesty for people convicted beyond a reasonable doubt of trying to overthrow the government, that is awful.
Would the gentleman yield?
Meanwhile, I would like to correct the historical record. My Republican colleagues seem to believe bail bonds are a relatively new phenomenon. However, the history of bail funds dates back to the 1920s when the American Civil Liberties Union set up a bail fund to release people arrested under harsh Department of Justice policies against people suspected of sedition during the first Red Scare. Similar to the ACLU's National Bail Fund, the Civil Rights Congress, a litigation and defense organization founded in 1946 to advocate for the rights of African Americans, workers, and dissidents, established a bail fund to make bail available to persons charged with political crimes. In the midst of the civil rights movement in the 60s, numerous bail funds were periodically established to free those fighting to end segregation and highlight the racist laws of the Jim Crow South in one of the deepest, darkest, worst periods of America before January 6 of 2021. In the midst of that time, and so one fund was the Mississippi Bail Loan Fund, established in conjunction with the Student Nonviolent Coordinating Committee, SNCC, to bail out protesters in Mississippi. And in 1965, the Congress of Racial Equality, CORE, and the NAACP created a temporary fund for protesters in Springfield, Massachusetts. Those funds did America a deed. They allowed people bail in communities where they weren't even allowed before a right to a fair trial. I yield back the balance of my time.
Gentleman yields back. Who seeks recognition? Gentlelady from Vermont is recognized.
Thank you, Mr. Chair. I yield to my colleague, Mr. Ivey from Maryland.
Thank you for that. I'll be very quick so I can yield time back. But just to correct some things that have been said a few moments ago, I think the gentleman from Arizona, the gentleman from Wisconsin were engaging in a dialogue there where the point was that this is regulatory only. And I just want to point out that the provision you are amending, 18 U.S.C. 1033, speaks in terms of punishment for an offense. There's a fine, imprisonment for not more than 10 years or both, and for the second penalty provision, which there may be embezzlement or something that aggravates the crime, that's up to 15 years, depending on the liquidation of the assets. This is not regulatory. This is criminal. This is, we're going to lock people up if they break this law. And as I said a few minutes ago, if you're good, this is the House Judiciary Committee. If you're going to lock somebody up for committing an offense, for violating a provision, it needs to be explicit and clear as to who's facing the criminal liability. And then just a couple other quick points. If you're talking about, we don't know which ones you guys want to criminalize with this, but if you're talking about somebody who's committing fraud using the internet or online or wire. Mr. Biggs, you referenced people sending money from across the country. Well, we already have federal provisions that deal with that. It's called mail fraud and wire fraud. Been in use. Federal prosecutors use them all the time. So if there's actual evidence of fraud being committed, the federal government can prosecute it. I bet the state governments do too. And by the way, just one last point on this front. At the federal level, if they're using tainted funds, the federal government can claw it back. They do it all the time. If a criminal defendant pays his attorneys using tainted funds, the prosecutors can take the money back through the court that was used to pay the defense lawyers. Happens routinely. In fact, defense lawyers trying to make sure, sometimes they'll even ask the prosecutors in advance if they can get paid from the fund that the defendant wants to use to pay them. Now, this isn't connected, I don't guess, to your provision here, because it's not clear what exactly you cover and what you don't. But all of those things suggest that what you're trying to do here not only is it not necessary because it's already covered, but it doesn't actually even get to the state issue because it speaks in terms of interstate commerce. By the way, I don't know what the commerce is, but it speaks in terms of interstate commerce. So that's for state provisions, and this provision, 18 U.S.C. 1033, is not intended to cover that. And with that, I yield back.
And at this point, I will yield the balance of my time to the ranking member, Mr. Nadler.
Thank you. I won't take all that time. I just want to point out, Mr. Bishop mentioned criminals free on bail. Most of the time, it's not criminals free on bail. It's people accused of crimes free on bail, although sometimes it's also criminals free on bail. Now, we have an example in New York recently of a person accused of very serious crimes who was free on bail, who was then convicted of very serious crimes, who is now free on bail. His name is Donald Trump. So I hope we don't condemn the bail system, and I yield back to Ms. Bayland.
I yield to Mr. Ivey from Maryland.
Just one other quick point I forgot to mention. The video that you showed, I do want to point out that I think they said that one person had been released on $75,000 bail for shooting at a police officer. Another was a twice convicted rapist. I never practiced in Minnesota, so I'm not crystal clear on this, but almost every state bail system, and I used to teach advanced criminal procedure, you can hold a violent criminal without bond until trial. Now, I don't know what those particulars were in that case. You had a judge decide to release them. But the point I want to make in addition to that is, whatever you're trying to do with this amendment here wouldn't change the decision the judge would have made at the time, because the judge has the ability to make the decision under every state law. There's no evidence of any kind of fraud, so whatever you're trying to do with this provision wouldn't correct it. And we don't even know who would be subject to your criminal provisions under this statute. So it doesn't do what you're trying to do, and in fact, it might create a mess because it's in conflict with the Bail Reform Act, which is the one that governs at the federal level. And with that, I yield back.
And I yield back to the chair.
Gentlelady yields back. Question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be
Chairman.
reported. Favored. Gentleman's recognized.
And that I ask for the yeas and nays.
Clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Gates? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Aye. Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Aye. Mr. Bishop votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes aye. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes aye. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Rulli? Mr. Rulli votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no. Ms. Ballant?
No.
Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Mr. Gates? Mr. Gates votes aye. Ms. Escobar, you're not recorded. Ms. Escobar votes no. Ms. Dean, you're not recorded. Ms. Dean votes no.
Oh, I know.
I feel unclean.
I hear you. Are we good?
Yeah, we're fine.
Clerk will call the roll.
Clerk will report.
Clerk will report, I mean.
Mr. Chairman, there are 14 ayes and 9 noes.
The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up 8666 to amend Title 28 United States Code to authorize holding court for the Central Division of Utah in Moab and Monticello for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 8666.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. H.R. 8666 was introduced by Rep. Malloy and co-sponsored by Representative Curtis. I have a statement for the record from Representative Malloy, and I would ask that it be included in the record.
Without objection.
The bill is very simple. It authorizes additional places for holding court so petitioners and jurors, especially in rural Utah, will have an easy access to court proceedings. As we all know on this committee, the right to a court is the very reasons that we have district and circuits throughout the country. Presently in Utah, there is only one federal judicial district, and in a state approximately the size of Oklahoma, which has 3, for example. The U.S. District Court for the District of Utah, which is broken into 2 divisions, the Northern and Central Divisions, in March of 2024, the Judicial Conference endorsed and recommended a proposal to form the District of Utah to add Moab and Monticello in the Southern District as additional locations for holding Central District meetings. In other words, we're not adding any bureaucracy, we're simply adding a building in which judges, juries, and the like can adjudicate cases. Accordingly, the Judicial Conference is adding these locations and suggests that not only would it be at no cost to the taxpayer because it is paid for by court funds, but this cost-free district has agreements with the state and county courthouses in those cities to use their facilities at no cost. This actually saves the federal government rather than holding them in Salt Lake or some other existing courthouse. Also, the 10th Circuit, U.S. Attorney's Office, and the Federal Public Defender's Office have all endorsed this proposal. For that reason, this is not a controversial bill, but in fact a good government and government savings bill, and one which, in this case, the Judges Act absolutely is consistent with, and I would ask that we move the bill without further amendment, and I yield back.
Chair, now the gentleman yields back. The chairman of the subcommittee on this subject yields back. The chair now recognizes the ranking member of the full committee for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 8666 would amend Title 28 of the U.S. Code to authorize holding court in the Central Division of Utah in Moab and Monticello. Congress organized Utah as one judicial district in 1894 with one authorized judgeship. The state's steady growth prompted Congress to add 4 additional judgeships at various points since then, and to increase the number of places to hold court in Utah. We are at another such inflection point today. Adding 2 additional places to hold court in the Central Division of Utah would help ameliorate the consequential barriers to jury service and court attendance faced by the federal courts in southeastern Utah. Moab and Monticello are geographically remote, making it difficult for Americans in those communities to readily exercise their 7th Amendment rights to a jury trial. We are here today because it makes no sense that litigants should incur dramatically increased travel time and administrative costs to seek justice just because that person lives far from the nearest big city. Legislation to help alleviate the burdens on our court system is widely popular on both sides of the aisle. Both of the court's bills before us today have been requested by the local federal district and the Judicial Conference. Small steps like those taken today are positive moves in the right direction. but they are not enough. The Judges Act, which I joined Chairman Issa and Ranking Member Johnson in reintroducing earlier this week, is the bipartisan help our courts need and would add the federal judges requested by the Judicial Conference over multiple presidential administrations. The Judges Act is the crucial step we need to take to ensure that our court system continues to function for the American people. We can add courthouses so Americans do not have to drive as far. We can reorganize judicial districts so that their structures make more sense given population fluctuations. But those changes mean nothing if there are no judges to hear the cases. We last passed the Judgeships Bill in 1990. Since that time, according to the 2020 census, we have added nearly 83 million people in the United States. Every day, the ratio of federal judges to Americans goes down. That means that every day our constituents are less protected by the United States court system than they were the day before. We can solve this problem today, and I hope we can all work together across the aisle to bolster our court system for the next 30 years. We can and should do more, and I am glad to work with my colleagues across the aisle to comprehensively bolster our court system. But we can start with the bill before us. Today's bill will not fix all problems in our justice system. However, it is a small step in the right direction to help the people of Utah gain equal access to justice. I thank Congresswoman Malloy and Congressman Curtis for sponsoring this legislation to improve the lives of the residents of Utah. I urge my colleagues to support the bill, and I yield back the balance of my time.
Gentleman yields back. Without objection, all other opening statements will be included in the record. Who seeks recognition? Question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Chair now calls up H.R. 7177. Pursuant to notice, I call up to amend Title 28 United States Code to consolidate certain divisions of the Northern District of Alabama for the purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 7177.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Alabama, Mr. Moore, for an opening statement.
Thank you, Mr. Chairman. H.R. 7177 updates Title 28 to improve the organization of courts in the Northern District and to accurately reflect each division that has been changed since the statute was last amended. The updates contained in the bill will ensure that Alabamians in the Northern District are properly assigned to the closest and most convenient federal courthouses when they have their cases heard or when they are called up for jury duty. Residents of Fayette County, for example, will be able to go to the closest courthouse in Tuscaloosa, and the folks in Cherokee County will be able to go to Anniston rather than a longer drive to Huntsville. Best of all, this bill has minimal cost for taxpayers, if any. This bill is supported by the Judicial Conference of the United States and the Judicial Council of the 11th Circuit, and it is co-sponsored by most of the Alabama delegation. I urge all my colleagues to join in supporting this bill and promoting the efficient administration of the justice of Northern Alabama. Thank you. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Chair recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 7177 would amend Title 28 of the U.S. Code to consolidate certain divisions in the Northern District of Alabama. By reducing the divisions from 7 to 5 and reorganizing some Alabama counties within those divisions, this bill would reallocate the judicial docket across the district, ensuring that 2.8 million residents of the Northern District of Alabama have access to a speedy judicial system. When courthouses close, we may not hear about it here in our nation's capital, but the people who live and work in those judicial districts are well aware of the deleterious effects of courthouse closures on the population. Office workers lose their jobs. Other nearby courthouses may become overcrowded. And thousands of people are left wondering if our system of justice will still work for them when they need it. That is exactly what is happening in the Northern District of Alabama. After courthouses closed, the district itself requested these changes, which were elevated to Congress by the Judicial Conference of the United States earlier this year. The changes prescribed in this legislation are not meaningless technical edits. Moving some Alabama counties to different judicial divisions can make a world of difference to the people who live and work in those counties. About 59% of the population of Alabama lives in the Northern District, which includes 31 of the state's 67 counties and two of the state's most populous cities, Birmingham and Huntsville. Because so many Americans rely on the Northern District of Alabama when they need to access our courthouse doors, the judicial system there must be able to spread a large volume of cases across its different divisions. But this is not only a question of apportionment. In a nation like ours, where the population is constantly evolving, our judicial system must be responsive to the needs of its residents, no matter where they live. Constituents in the different divisions of the Northern District of Alabama deserve a courthouse that is geographically convenient and does not require a drive hours away from home. Responding to the needs of these residents is a small step in the right direction towards making our judicial system work for everyone, not just those who are fortunate enough to live close to a federal courthouse in a big city. I thank the representatives from Alabama, especially the sponsor, Congressman Strong, for introducing this legislation. I urge my colleagues to support the bill, and I yield back the balance of my time.
Gentleman yields back without objection. All other opening statements will be included in the record. The question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all amendments, and staff is authorized to make technical and conforming changes. Chair now calls up. Pursuant to notice, I call up H.R. 115, the Midnight Rules Relief Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 115 to amend
Without
Chapter
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Arizona, Mr. Biggs, for an opening statement.
Thank you, Mr. Chairman. This bill is the Midnight Rules Relief Act. It's an important piece of legislation that will allow Congress to more effectively and efficiently oversee federal agency rulemaking, which is one of our constitutional obligations. Under the Congressional Review Act, known as the CRA, executive agencies must report all promulgated rules to both chambers of Congress. This reporting requirement allows Congress to consider federal regulations before they take effect. The CRA also recognizes the authority that Congress has to pass joint resolutions to prevent agency rules from taking effect. CRA's disapproval mechanism gives Congress a check on federal administrative overreach. However, the CRA forces Congress to introduce a single, separate joint resolution for each agency rule it seeks to render unenforceable. And this one-by-one limit to joint resolutions under the CRA slows Congress's oversight of agency rulemaking. Its inefficiency is most clear during the midnight rulemaking period of the last year of our president's term, which, as the CRS has reported, here's some of the reasons that you see this happening. Because the administration that's outgoing realizes that they want to complete their work and achieve certain policy goals before the end of its term of office, so they know that it'll be more difficult to change or eliminate rules after they've taken effect. They issue midnight rules. One concern that outgoing administrations have is that they have less political accountability. So they do what they feel they can do and get by with. Rules that are hurried through, another concern is that rules that are hurried through at the end of an administration may not have the same opportunity for public input. Another is that the quality of regulations may suffer during the midnight period, since the departing administration may issue rules quickly, and as a result, the rules may not receive adequate review or analysis. And additionally, the task of evaluating a previous administration's midnight rules would overwhelm a new administration. Thus, we see outgoing administrations issuing very significant rules on their last year, and that's what this bill addresses. And so if you look at the CRS data, it doesn't matter a Democrat or Republican administration. They're trying to cram down a bunch of rules in that last year for the reasons that I've just iterated. So what this bill would do is it would make Congress's oversight more efficient during the midnight rulemaking period. The Midnight Rules Relief Act would allow Congress to introduce joint resolutions considering multiple agency rules during the final year in a president's term. And this change would allow Congress to efficiently respond to the influx in agency regulations during the midnight hours of the president's term. And this particularly gets at one of the reasons that an administration would go ahead and proceed to do this is that it would overwhelm the new administration. So you are actually facilitating review of the outgoing administration, and you're actually facilitating and helping the new administration as well. So with that, I urge support of this, and I yield back, Mr. Chairman.
The gentleman yields back. The chair now recognizes the ranking member, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the bill before us today is not really about addressing midnight rules, but rather about our Republican colleagues pushing their anti-government deregulatory agenda under cover of darkness. H.R. 115 may appear to be a modest change to the Congressional Review Act, but don't be fooled. If Donald Trump becomes president next year and Republicans gain complete control of Congress, this bill would allow them to wipe out months' worth of regulations issued by the Biden administration in a single party line vote. This scenario is not far-fetched. In 2017, after Donald Trump was inaugurated, the Republican Congress used the CRA to repeal 16 rules issued by the Obama administration. Critical rules on teacher training, internet privacy protection, and the prevention of water pollution from coal mines, among many others, were all repealed over a few short weeks. But it seems that Republicans have even bigger ambitions for their next deregulatory spree. Rather than consider agency rules on their individual merits, they want to package as many rules as possible into a single resolution to eliminate them all at once, with little debate or deliberation over the merits of each individual rule. The results of this single vote could be catastrophic. A single resolution would not just repeal those rules, it would prevent the agencies that issued them from proposing similar rules ever again. Why do Republicans feel they need this power? Maybe it's because they realize that many of the agency rules that they constantly rail against are actually popular with the American people. Taking a series of votes making it easier for corporations to pollute the environment or take advantage of the most vulnerable would likely not be well received. Better to overturn as many rules as possible in a single vote, reducing transparency and obscuring the consequences. No surprise, then, that this bill is one of the mandates outlined for a second possible Trump administration in Project 2025. But make no mistake, whether those votes are held individually or en bloc, the American people will be the ones to bear the consequences. Although the full extent of Biden administration rules that could be impacted by this provision won't be known until the end of the year, if Republicans are left in charge of the House, it is likely that every rule the administration issues in the second half of this year would be on the chopping block, along with the protections those rules provide to our constituents' health, safety, and economic well-being. Mr. Chairman, members of Congress on both sides of the aisle have recognized that midnight rulemaking, if left completely unchecked, can lead to abuses by the executive branch. At the end of President George W. Bush's administration, I authored a bill that would delay implementation of rules issued near the end of a president's term, giving his or her successor the chance to review midnight rules and to determine if they should go forward. I believe there are ways we could work together in a bipartisan manner to address this issue. But where past efforts tried using a scalpel to address the problems associated with midnight rulemaking, today's Republicans would instead insist on using an axe, hacking away at the Biden administration's regulatory agenda and furthering their ideological goal of radically transforming our government. It should go without saying that this is no way to legislate. I urge my colleagues to join me in opposing this bill, and I yield back my time.
Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Arizona for purposes offering an amendment in the nature of a substitute.
I have an amendment at the desk.
The clerk will read the
Amendment in the nature of a substitute to H.R. 115 offered by Mr.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of the amendment. The chair now recognizes the gentleman from Arizona to explain his amendment.
Yes, thank you, Mr. Chairman. This amendment strikes the year from the title of the bill. This amendment is not intended in any way to alter the substance or important purpose of this bill, and I urge support for the amendment, and I yield back.
Does anyone else seek recognition? The gentlelady from Washington. The gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I too, unfortunately, rise in opposition to this bill. I believe it would have an unprecedented impact on the government's ability to protect American workers, consumers, and families. And I want to start just by talking about our current regulatory process, because I think it's not that clear to people exactly what's happening. Many Americans are taught in civics classes that Congress passes a law, and that's it. But the truth is that major legislation enacted by Congress to address issues like worker safety, clean water, and health care have to actually be enforced by the executive branch in order to become a reality. Public agencies implement legislation that we pass through administrative rulemaking, creating regulations to implement the law. This bill takes the Congressional Review Act, which allows Congress to quickly repeal rules in their entirety, and it actually turns it into a sledgehammer, allowing Congress to take up multiple unrelated rules in a single bill instead of considering each rule on its merits. Moreover, when Congress overturns a rule through the CRA, that rule or any, quote, substantially similar rule cannot be reissued in the future. This bill would severely hinder the government's ability to implement the law. And maybe that's the point by some of my colleagues, to overturn so many rules through the CRA that the government's ability to protect Americans through rulemaking becomes severely restricted. It's no coincidence that Trump's Project 2025 agenda explicitly calls for the passage of this bill. I know the rulemaking process is far from perfect, and I do think there are things we could work on together with both sides of the aisle to try to help fix some of those things. But all rules, including the so-called midnight rules targeted by this legislation, are subject to months or years of administrative process, public input, and consideration. According to studies by Public Citizen and the Administrative Conference of the United States, the vast majority of rules passed at the end of a presidential administration are routine rules that had been under consideration for longer than average. These studies show that there's simply no factual basis for the claims made by my Republican colleagues about these rules. And Mr. Chairman, I ask unanimous consent to enter these two studies into the record.
Without objection, they'll be placed in the record.
Thank you, Mr. Chairman. There are real problems with the current rulemaking process that do have to be addressed, and that's why I'm proud to sponsor the Stop Corporate Capture Act to make much-needed reforms to strengthen our regulatory system. Big corporations with their well-heeled lawyers and lobbyists have outsized influence in the rulemaking process. These corporations secretly fund studies by academics and researchers that favor their positions without disclosing their funding or their conflicts of interest. Moreover, it can be difficult for regular Americans sometimes to participate in the regulatory process, and the process is excessively slow. These are real problems that undermine our government's ability to work efficiently to promote the public interest. My Stop Corporate Capture Act would increase transparency, would reduce the undue influence of big business on the regulatory process, allow the public to better access rulemaking, and make regulation faster and more efficient. Stop Corporate Capture would build on the regulatory successes we've seen in this administration, ensure that regulations more effectively promote the public good and protect American workers, consumers, and families. That should be our goal here in Congress. Just look at all the good work that's been advanced by the Biden administration through the regulatory process in just the last few months. Regulations that ensure that workers receive the overtime pay that they actually have rightly earned, promote clean water free from harmful forever chemicals, and outlaw predatory junk fees. This rulemaking is transformational for millions of Americans. Rather than improve the regulatory process, the bill we're debating today would create an expansive new tool for anti-regulatory extremists to prevent our government from acting to protect all Americans. It would allow Congress to overturn dozens of regulations simultaneously with minimal public debate or process. And it fixes none of the real issues that we do have with the regulatory system. Instead, it would turn the Congressional Review Act into a sledgehammer for special interests, not strengthen. It would weaken, not strengthen our government's ability to address the real issues facing Americans today. I urge my colleagues to oppose this bill, and I hope instead we can work together to advance my Stop Corporate Capture Act. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. The question is on the adoption of the amendment in the nature of a substitute.
Mr. Chairman, may I be?
Who seeks recognition?
I do, Mr. Chairman. Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I just want to make a couple of quick points, and we can move forward. But the suggestion that this would only get to quote-unquote midnight regulations, I think, is misplaced, to say the least. As I think Ms. Jayapal just explained, most of the regulations that would be captured by this have been going through a process under the Administrative Procedures Act that provides due process for public comment. Then the comments are then published, and people can follow up on those comments. There's an entire process in place to allow a debate with respect to whatever the regulation is. And the debates are often very vigorous. I had, during my career in private practice, I engaged in that on behalf of some clients. And, you know, it's a process that is very rigorously debated, and it's all in the public. It's very transparent, and there's an opportunity to address concerns. Now, under the current law, Congress already has the ability, if they want to challenge one of these and reject them, they can do that. But 2 points to make on that front. We've only used the CRA twice, if I'm reading correctly from this CRS document that was published August 29, 2024. So if we've only used it twice, I don't know that there's a tremendous need for it, at least based on the way we've used it or not used it in the past. And the point that was also made, if you strike down one of these regulations using this resolution process, under the current law, there's an issue about whether you can reissue that regulation again, even if you go back through the process. I think it's excluded to some point. So the irony here is you've got a long, extensive, transparent process that's in place under the Administrative Procedures Act where these issues can be debated and are, and frequently are, in contrast to what this bill would do, which is to create a vehicle where you could push an unlimited number of regulations and abolish them essentially, permanently, just on a single vote. And by the way, I don't know how the jurisdictional piece would work here, because potentially you could have regulations coming from all different jurisdictional areas. I don't know if each committee that has jurisdiction over a particular regulation would have a chance to have a hearing on it before it goes into this bill, because potentially you could push dozens of regulations into here, and I know every committee's not going to do that. So let's work with the process at a minimum that we already have. If you've got a legitimate basis for challenging a regulation, you've already got a statute in place that allows you to do that. And as Ms. Jayapal pointed out, there are other, and the ranking member as well, if we want to try and resolve or fix potential problems with the way the APA works now, let's focus on that. But this approach isn't the right way to go. And with that, I yield back the balance of my time.
The gentleman yields. Who else seeks recognition? The gentleman, Mr. Biggs, is recognized for 5 minutes if you're striking the last word.
Thank you, Mr. Chairman. I find intriguing the arguments against this, because the argument, when you listen to this, well, you know, you already have that process now, and we've only been used it twice. That's an error. CRS reports we've used it 20 times. We've used it 20 times. And when you start talking about we're going to emasculate all these rules, which have gone through this massive process, and oh, by the way, we could do that now. I mean, do you not see the inherent speciousness of that argument? So let's go forward and let's just talk about this for a second. So from the Clinton administration, rules that we considered to be midnight rules, that last year, which is what the bill is dealing with. In 1999, his second to last year in office, his agencies passed 30 major rules. What's a major rule? Has an immediate impact over $100 million. That's the definition. But in 2000, he increased it by 77% to 53. Those are major rules. And Congress and the new administration is almost invariably unable to process and get through those. What did George W. Bush do? He had 41 major rules in '07. That increased by 54% to 63 in his final year. Now, this body, Congress, it is our oversight duty per the Constitution. We provide the funding for these agencies. We provide the funding for these programs. And if you want a concrete example, when I was first elected, or when I was running, I should say, I went over to Senator Mike Lee's office, and he said he had this massive stack of paper, like 12 feet high. I said, "What in the heck is that?" And he said, "Oh, this stack right here is about 8 to 10 inches high. This is laws actually passed in the last session by Congress." I said, what is this big tall pile you've got? He says, "Those are the regulations promulgated by rulemaking authority by the bureaucratic state in the same period of time." So I hear you say, well, you know, we can do this already. So let's not expand our authority. Let's not expand what we're doing. Let's continue to put speed sticks down on what is our constitutional obligation. It's our constitutional obligation to oversee what they're doing. And I'm bewildered by that argument. If there was a different argument, a better argument, I would say, maybe we should think about that. But you know, the reality is, when push comes to shove, there are other ways to skin that cat. And how'd that happen? Well, this administration came in and said, we're not going to do CRAs. We don't give a rip what Congress says. We're just going to, through executive order, start repealing virtually every border security policy, like something like 100 in 72 hours. That's what this administration did. And you know what? Those all should have probably come back to this body for review, oversight, and consideration. That's what I'm trying to do.
Will the gentleman yield?
Yeah.
Okay. First of all, on the executive order point, this bill doesn't touch on that.
That's correct.
Right? Okay.
That's
We'll
correct.
set that to the side.
But the point is similar.
Fair enough. But with respect to the regulation argument that you're making, Congress already has the authority to do what you just said we're trying to do. We just need to do it one at a time. And I assume the logic of that is to make sure we know what we're doing when we repeal a regulation.
But I'm going to reclaim for a second. Let's respond to that.
Yes, sir.
How many have we done? 20, right? That means we don't give jack crap rip about them. Because if we did, we would be going through that 12-foot stack of regulations, because that's about what it is every time. Do you know how many federal crimes are created by regulation?
Is the gentleman...
No, I mean, it's my time. There are more than 40,000 felonies created by regulation. Have you looked at those?
Let me ask you.
No. It's back on me. You're saying we have the authority now. And I'm saying you do have the authority now, but we're not exercising it. And the reason you're not exercising it is because of the speed stick that is down that prevents you from efficiently doing so. And that is our responsibility, and that's why we should pass this bill and yield back.
Who else seeks recognition?
Yeah, Mr. Chairman.
The ranking member is recognized to strike the last word.
Strike the last word, and I yield to Mr. Ivey.
Thank you, Mr. Ranking Member. Just a quick point. So I guess what you're arguing is you don't want to review the individual regulations. You just want to put them all in a single bill and repeal them all at once. Is that your point? Because
Are you yielding to me? Are you yielding to me?
Otherwise, just a second.
Oh, I thought you were yielding.
Otherwise, you can just go through them under the current law and repeal them using the current law. Now I yield to you.
Thank you. That's not what I'm saying at all. What I'm saying is the single law saying, well, you get to look at one rule at a time. One rule at a time is so inefficient that it doesn't allow us to get together and get moving on this stuff. And I'm not saying there's no way in the world we're going to...
Chairman, I reclaim my
time.
I reclaim my time, and I yield to the gentlelady from Washington.
Thank you, Mr. Ranking Member, for yielding. I think there's an underlying assumption here that these rules are all passed quickly, without process, because it's the end of an administration. And I just wanted to quote something from the ACUS report summary. This is a direct quote. "The conference has found that a dispassionate look at midnight rules issued by past administrations of both political parties reveals that most were under active consideration long before the November election, and many were relatively routine matters not implicating new policy initiatives by incumbent administrations. The conference's study found that while there are isolated cases of midnight rules that may have been timed to avoid accountability, the majority of the rules appear to be the result of finishing tasks that were initiated before the presidential transition period or the result of deadlines outside of the agency's control, such as year-end statutory or court-ordered deadlines." And I raise this point because I think it's important. The fact that the CRA was used 20 times is not necessarily a bad thing. The question is how many of these rules should be reviewed and should be brought to the attention, and is there a process for that? There is a process for that. The reason that they are one by one versus in the entirety together is because the vast majority of these, as the conference has said, have gone through an extensive process. So why should we, as Congress, suddenly say that that process is invalid and we're going to lump a whole bunch of them together? I think there is an appropriate speed stick, I think you called it, but an appropriate set of measures to make sure that there's a process if we do want to repeal them, but also that it is considerate of the process that has gone through, the administrative process that has gone through, that actually established those rules to start with. And I think we have to get rid of the idea that somehow there's a bunch of stuff that gets done at the end of a presidential term that hasn't gone through a lengthy process. Thank you, Mr. Nadler. I yield back.
I yield to Mr. Ivey.
I'll be brief, but you can't have it both ways. You can't say that there's a process in place that can do them one at a time, but there's so many coming through that we can't review them. And so we're going to put them all together and move them through under this provision, but then say like, but we're actually reviewing and making determination about what goes in there. Because if you actually are making that determination, reviewing, as Ms. Jayapal just pointed out, you can do it under current law, and we should. If you really feel that strongly that something is inappropriate or it's wrong or it violates the law, bring it up, but you can do that under current law. What this does is, as Ms. Jayapal points out, it gives the ability to push through things without even reviewing them and making a determination that there's something inappropriate about it. And then to the point that she also made, the verb you use in this provision is submitted. And by the definition in the current law, that just means whenever they send it to Congress after the regulation has been promulgated.
Mr. Chairman, reclaiming my time, I just want to point out, under current law, if you review a given regulation that was put forward by the outgoing administration, the American people see you reviewing it, they can judge it, they can judge what you're doing. Under this bill, under which everything goes through one bill, the American people have no ability to follow what's going on. The American people have no ability to see what the new majority is doing and judge it, because 30 different regulations on 30 different topics are being repealed in one vote, and nobody has the opportunity to understand the 30 different things that are being done. That's why this is wrong. There's nothing wrong with the Congressional Review Act. We agree that a new administration may, or a new Congress majority rather, may wish to review the actions of the outgoing administration and do it publicly and debate it, and the American people can and act on it, and the American people can judge it. But to do it all in one vote, 30, 40, 50 regulations, the American people have no ability to see what you're doing, to make judgments, and that is wrong under democratic government with a small d, and I yield back.
For what purpose does the gentleman seek recognition?
To speak to the measure.
Gentleman's recognized for 5 minutes to strike the last word.
Thank you, Mr. Chairman, and I'm momentarily going to yield to Mr. Biggs. I think the arguments against this are disingenuous. I just think they want to have as much cumbersome obstruction so that Congress can't efficiently move against all these regulations that are being promulgated beyond agencies' authority. It's a chaos theory or an or flood the zone kind of strategy. You've got massive increase in the bureaucracy, massive increase in the numbers of rules. Congress has to go through its protocols, its committee process, all the competing measures before it can act to override any of these regulations. And let me ask this to the gentleman from Arizona. Under the bill that you propose, if you had multiple regulations in a single bill being overridden, could someone offer an amendment in committee or on the floor, if it were allowed by the Rules Committee, to take a particular rule out of the number being amended or being overridden?
Yes, sir. This bill does not change the procedures of the House for regular order.
So you got 435 members here who can give exacting scrutiny to the bills to the regs that are being overridden in such a measure, and take any of them out that shouldn't be included. Is that right?
That's correct.
Then, like I said, I think the arguments against this are disingenuous.
Would the gentleman yield for a question?
I'm going to yield to Mr. Biggs because he's been on fire today.
Yeah. Well, what I would say this that I find really interesting about the argument for the ranking member is that, good grief, the American people, if you did 4 or 5 rules in one bill, good grief, the American people would not be able to see it and know what's going on. How many of the 40,000 plus felonies that most Americans have no idea exist on this committee? How many of you have been keeping track of the rulemaking of the agencies that we supervise? When did you last put in a submission for the public consideration on a rule? Probably rare. How about this? How about this one? This is a beautiful idea. You say, okay, you know what? If you did this and you had multiple rules considered here, man, it's almost like, I don't know, like a spending omnibus package that you get at the last minute and you're voting on and nobody knows what it is. No, this bill doesn't say you're obviating anything. You're not changing the rules of procedure of the House. What you're just saying is, look, there's 15 rules we saw come out of there. We don't like them. We think they're inappropriate. We want to have a debate. We want to do it. Why not do that? Yeah. No, because you know why? Well, you know why? It's because you don't want people to actually start overturning rules of a previous administration.
Will the gentleman yield for a question?
I don't control the time.
I would put a slightly different spin on it. I mean, that's right. They want Congress, just like it is, disabled from recovering its responsibility to enact law.
Article 1.
They like laws to be promulgated as fast as they possibly can so that the American people can be controlled that way. Well, and they want to make sure the unresponsive, the mechanism that creates so much law that is so unresponsive to the people, that has no consent of the governed, that it continues to build and grow. Any measure to cut that back, they're hostile to.
Will the gentleman yield for a question?
Certainly.
How many CRA hearings has this committee held in this Congress?
Not very many, because that's
Maybe
the
zero?
whole point.
Maybe zero?
There's a lot of stuff competing for attention. Why would you disable the Congress, which cannot act efficiently, from acting efficiently? It makes no sense whatsoever. And I yield to the chairman if he wanted for the rest of my time.
Just a question, perhaps, for Mr. Biggs. Isn't it true that CRA only can be used when you have the control of the House and the consent of the president?
Yes.
And so isn't it true that really this is a hypothetical for a hypothetical outcome based on the fact that most of the time we do not have that so-called trifecta. We don't have the lineup that would allow the House to pass it and get it. And that is a rare occasion, and that may be the reason that there's only been 20 of these or so done, is the opportunity comes by very seldom.
That may be one of the reasons, sir.
And isn't it also true that the midnight portion is a fraction of the rulemaking, since most of the rules are made in regular order in the first 3 years, 3.5 years, and not in the last days of a administration?
Yes, sir, except for you have 50, 60, 70, 100 million plus impact rules, major rules, considered major rules, usually in that last.
Exactly, that it is a unique thing that when you say midnight, you are talking about in the 4th or the 8th year of an administration, often only after they know the outcome of the election, that that these rules get promulgated.
Yes, sir.
Thank you. I yield back.
And I yield back.
Anyone else seek recognition? We've exhausted it. Therefore, the question is on the adoption of the amendment in the nature of a substitute. This will be followed by an immediate vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is now on favorably reporting the bill as amended. All those in favor say aye. Aye. Any opposed say no.
No.
In the opinion of the chair, the ayes have it.
Mr. Chairman, we record a record vote. We request the record vote.
Right. A recorded vote being ordered. The clerk will call the roll.
Mr. Jordan. Mr. Jordan votes yes. Mr. Issa.
Aye.
Mr. Issa votes aye. Mr. Gates. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes aye. Ms. Sparts. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Bentz. Mr. Bentz votes aye. Mr. Klein. Mr. Armstrong. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes yes. Mr. Nels. Mr. Moore. Mr. Moore votes yes. Mr. Kiley. Ms. Hageman. Mr. Moran. Ms. Lee. Mr. Hunt. Mr. Hunt votes aye. Mr. Fry. Mr. Ruley. Mr. Nadler. Mr. Nadler votes no. Ms. Lofgren. Ms. Lofgren votes no. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Swalwell votes no. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes no. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes no. Mr. Neguse. Ms. McBath. Ms. Dean. Ms. Dean votes no. Ms. Escobar. Ms. Ross. No. Ms. Ross votes no. Ms. Bush. Mr. Ivy.
No.
Mr. Ivy votes no. Ms. Ballant.
No.
Ms. Ballant votes no. Mr. Garcia. No. Mr. Garcia votes no. Mr. Gates.
Klein. Oops. Go ahead.
Mr. Gates votes aye. Mr. Klein votes aye. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Ruley. Mr. Ruley votes aye.
The clerk will report.
Mr. Chairman, there are 14 ayes and 10 noes.
The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 9605, the No Censor on Our Shores Act, for purposes of markup, and move the committee report favorably to the House. The clerk will report the resolution.
H.R. 9605, to provide that any foreign government official who engages...
Without objection, the resolution will be considered as read and open for amendment at any point. The chair now recognizes himself for a short opening statement. The No Censors on Our Shores Act is an important piece of legislation, and I'm pleased to have introduced this legislation with Representative Salazar just this Monday. This bill is timely because it will give our country a tool to punish foreign officials if they violate Americans' First Amendment rights here in the United States through their actions around the world. Unfortunately, violations are not speculative. Through this committee's work, we have uncovered remarkable examples of foreign censorship affecting Americans and American-based platforms. Around the world, foreign government officials have sought to silence disfavored speech by mandating the American-based platforms censor that speech. They have done so even though the speaker resides outside the jurisdiction of that country and often normally resides within the U.S. This legislation only concerns U.S. citizens. However, the reach will be foreign government officials, including those in Brazil, those in Europe, and even those in Britain, who are trying to force American companies to censor Americans' constitutionally protected speech in the United States. The Brazil Supreme Court Justice ordered X Corp, formerly known obviously as Twitter, and Rumble, two American companies, to take down posts and accounts that criticized the current Brazilian government. American free speech is the most fundamental part of our Constitution, and we have fought for that speech here and around the world. We have defended and helped establish those very countries that often do not want to hear our criticism by Americans. You can't have it both ways. If America is going to be a beacon of free speech and liberty, we have to continue to insist that that is around the world. Can anyone here imagine if Radio Free Europe were taken down, or any of the other truth statements that America sponsored throughout the Cold War? The fact is, around the world, we would not have had the kind of breakthroughs of democracy if we had not been able to tell the truth here in the United States and then spread that. I want to give one more example. Just last month in UK, British officials expressed a desire to prosecute American citizens residing in the U.S. for their online speech questioning mass immigration into the UK. Most Americans would believe that the British citizens should be able to say it, and that, of course, we should be able to either echo it or to say it in an original form, but that may not be the case. The reality is, around the world, there is a tendency to stifle speech that governments do not like. For that reason, I have offered this legislation, the No Censors on Our Shores Act, to give us a tool to punish in a very limited and surgical way foreign officials when they violate U.S. citizens' First Amendment rights here in the United States. It amends the Immigration and Nationality Act to make foreign government officials inadmissible or deportable from the United States if the foreign official censors Americans in the United States or otherwise committed an act that would violate the First Amendment if done by a U.S. official. Holding foreigners from preventing foreigners coming to the United States if, in fact, they act in a way inconsistent with U.S. law is a long tradition, but one for which there is no specific statute. In short, if a foreign government official seeks to silence Americans, you shouldn't be able to enjoy the benefits of living in America. I urge support for this bill and yield back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, let's take stock of where we are. In 12 days, government funding will expire. Members of the military, federal law enforcement officers, and more than 4 million federal employees will stop receiving their paychecks. The Small Business Administration will stop approving the loans that small businesses rely on to keep their doors open. The Environmental Protection Agency will stop conducting drinking water inspections. Social Security, Medicare, and Medicaid will stop verifying benefits and issuing new cards. And if the shutdown goes on long enough, they may be forced to stop granting benefits at all. The National Park Service will likely shut down completely, and the National Institutes of Health will stop accepting new patients. This is just a small snapshot of the impacts ordinary Americans will face if Congress cannot come together to fund the government in the next week and a half. Unfortunately, my majority counterparts seem utterly disinterested in making this happen. Last night, Speaker Johnson moved forward with a vote on a continuing resolution that he knew could not pass, and as predicted, it failed by nearly 20 votes. He still has not put forward any proposal that might actually garner a majority. And today, here in this committee, are we doing any work that might help resolve this pending crisis, or that might address the myriad other issues that Americans are facing, such as the continued threat of weapons in our schools? No. Instead, the majority has chosen to take up legislation designed to protect and help one man and one man only, Elon Musk. Protecting billionaires has been a theme for the majority of this Congress. This committee has held multiple hearings on the investigations into now convicted felon Donald Trump, all in an apparent effort to interfere in ongoing prosecutions. It advanced legislation to move the case against Trump, and only the case against Trump, from state court to federal court. And under the chairman's signature, it has sent repeated letters asking questions about baseless conspiracy theories. Now the committee is doing the same to protect Elon Musk and his pet project X, the social media platform formerly known as Twitter. In January 2023, that is to say last year, Musk met with Republican leadership and Chairman Jordan without any representatives from the minority present. After this meeting, the majority launched multiple investigations designed to impose burdensome document production and interview demands on Twitter's rivals and on any entity who dared to criticize Twitter or Musk's management of the company. Chairman Jordan has launched burdensome and expensive investigations into every major social media company except Twitter. He has attacked the Federal Trade Commission for having the audacity to investigate whether Twitter is misleading consumers. He sent a demand letter to Meta demanding information on its decision to launch Threads, which the chairman derided as a, quote, rival of Elon Musk's Twitter, close quote. After Senator Warren wrote to the SEC asking the agency to investigate whether Mr. Musk had a conflict of interest as CEO of both Tesla and Twitter, the chairman sent a letter to the FTC demanding communications between FTC employees and Senator Warren's former staffers. When Elon Musk sued the Center for Countering Digital Hate for reporting on the rise of hate speech on Twitter, Chairman Jordan promptly wrote to CCDH and demanded broad swaths of documents, demands clearly designed to obtain material that would take Twitter months, if not years, to obtain through the civil discovery process. And just recently, the chairman decided to attack the Supreme Court of Brazil and the European Commission for having the audacity to try to stop the spread of disinformation on Twitter. Disinformation that is leading to rampant violence and threats of violence in the case of Brazil, and which violates European law in the case of the EC. I am sure it is just a coincidence that this year, the Musk-backed America PAC plans to spend $160 million to help Republican candidates, that Musk has promised to turn out 800,000 people to vote for Trump in battleground states, and that just this week Musk pledged to spend $10 million for, quote, voter turnout in House races across the country. And I'm sure it is just a coincidence that we're here today to consider legislation to help exactly one man, Elon Musk, even though just this week, following the assassination attempt against Donald Trump, Musk tweeted and then deleted, quote, and no one is even trying to assassinate Biden/Kamala, close quote, punctuating his sentence with a thinking face emoji. While this legislation is designed solely to help Elon Musk, it is drafted so broadly and so carelessly that it would have what I must assume are a wide range of unintended consequences. The legislation purports to make inadmissible or deportable any foreign official who carries out an act against a United States citizen that might constitute a violation of the First Amendment. This is obviously directed towards the Supreme Court of Brazil and the European Commission. The majority has accused both entities of trying to, quote, censor Elon Musk. In practice, however, this legislation is unworkable. I presume, given the title of the bill and their advocacy for Musk so far, that the majority means this bill to apply to a narrow category of cases related to speech online. But that is not what the bill says. The bill says, quote, First Amendment, close quote. As the majority must know, there's far more to the First Amendment than Twitter and Elon Musk. This bill would apply, for example, to the Pope, a government official in his capacity as the ruler of Vatican City and the Holy See, who regularly directs American bishops in their exercise of religion, and who also has authority to punish American clergy who speak out against him. It would apply to Saudi consular officials who deny tourist visas to non-Muslim U.S. citizens seeking to access either Mecca or Medina. And it would apply to any foreign officials whose government hires American employees to work in their embassy and then limits what those employees can say about their jobs. The legislation is also unworkable because there is a significant, complex, and voluminous body of case law interpreting and applying the various clauses of the First Amendment. I cannot fathom how a State Department official charged with reviewing a visa application without benefit of an extensive record present in an American court case or any extensive familiarity with First Amendment doctrines and case law would have the ability to determine whether acts committed by a foreign official in another country, quote, would violate the First Amendment, close quote. Even if the authority granted to executive branch officials under H.R. 9605 is discretionary, and Republicans have argued in other contexts that federal immigration officials' discretion in prioritizing the deportation of foreign nationals is limited, it would not solve the problems highlighted by these examples. Indeed, it might prove more problematic because executive branch officials would have the discretion to pick and choose which U.S. citizens' rights should be vindicated by deporting or denying a foreign official entry into the United States. This legislation is simply absurd and unworkable. I urge my colleagues to vote against it, to stop using this committee as a vehicle to advance Elon Musk's personal interests, and to move on to issues that are actually important to ordinary Americans. I yield back.
Gentleman yields back. The chair will make the ranking member aware for the record that Twitter was subpoenaed. With that, I have an amendment at the desk, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 9605. Offered
Without
by
objection, the amendment will be considered as read. The chair now recognizes himself to explain the amendment. The amendment modifies the bill to bill's punctuation. It changes and clarifies in the meaning of the bill and makes it more easily understood. It is not intended in any way to alter the important purpose of the bill, and I urge the amendment, and I yield back. The chair now recognizes the gentleman from Maryland.
Thank you, Mr. Chairman. I've got a couple of questions. One is, this states that if there's a determination that the statement would violate the First Amendment to the Constitution, who would make the determination as to whether there's been a First Amendment violation?
Mr. Ivey, I appreciate that if you'd yield.
I yield.
As a member of Foreign Affairs, I've worked with the State Department for many years. The determination of the admissibility of somebody is generally done at the visa granting time. And so what would happen is when they come before the State Department asking for a visa, if there's been evidence or they're on a list that has been given to them, they would prohibit it. If that was not made available, they probably would be granted it.
Okay.
Now,
Well,
if I can just add one more thing. This kind of technique, for example, has been used regularly for example, people who give money to Hezbollah or some other.
Let me reclaim my
excludable.
time based on that, because that's one where you've got Hezbollah that's on a list that's been determined by the State Department as a terrorist organization, and you would have presumably a document of financial records that show the contribution. So that's pretty straightforward. A determination
Would the
about
gentleman
whether there's,
further yield?
if I might, just for a second, if there's a determination about a First Amendment violation, which, as far as I know, isn't particularly within the expertise of the State Department, and normally would be made by a court of law, and I don't see any court process involved in this amendment here. How would the State Department be best positioned to make that determination?
I appreciate that, gentlemen, for the yield. Homeland Security and other agencies regularly are the sources undercover. In other words, an individual who is denied entry, for example, for a donation to a group or an association with a group often would not be told the reason, nor would the State Department.
Well, if I might reclaim my time, I'm not talking about disclosure. I'm talking about the actual constitutional determination that there's been a First Amendment violation. And there's nobody in the State Department particularly that has expertise with respect to that. And I'll add this as well. I mean, the ranking member's comments about, the Pope, for example, I think kind of are particularly resonate with me, but also in the reverse of that. I mean, if we're going to start, I think, stepping into the State Department determinations about who should be allowed to come with obvious diplomatic implications, isn't there a concern about some sort of retaliation coming from other countries, and especially countries, even allies like the UK, that don't have a First Amendment constitutional provision to govern the conduct of, say, a judge who might make a decision with respect to, I don't know, imposing, and I'm saying I don't know a lot because this isn't real clear about the scope of the First Amendment that's covered here. There could be religious implications, there could be speech implications, there could be assembly implications. There are all sorts of things that could fall under this rubric, none of which the State Department is particularly well prepared to make those determinations. There's no court provision for doing it, and I think there's a real concern that I have, at least, about possible retaliation from a diplomatic front. But I'll yield to the gentleman again for comment.
Well, I think it's important to know that the State Department regularly does exclude people for violating people's religious freedom, for example. Certainly, there's no adjudication there. There's a determination that government official has done
Let's hash that out. Violating people's religious freedom here in the United States?
No, in their country.
Okay, well, but you're talking about somebody who's in the United States explicitly under your amendment here.
Right, we're much more limited in that.
So the example you gave isn't applicable under this provision, right?
No, absolutely, this is a much more limited and nuanced restriction.
Well, okay. I appreciate the gentleman's comments, but I don't think they explain really how this would work, certainly not from a legal standpoint, since there's no apparent process in place for someone who, let's say, is excluded, having the ability to challenge that on constitutional grounds that don't apply to them because they're foreign officials. Big problem, I think. And then the diplomatic spillover, I think, potentially is very problematic. And I'm not aware of us having any kind of hearing where we explored that with our sister committees or the State Department about that. And I see my time's expired, and I'll yield back.
Mr. Chairman? Mr. Chairman?
We'd recognize the chairman of the full committee.
I think the Chairman, thank you for this bill. State Department, you all were fine with Homeland Security setting up the Disinformation Governance Board. A bunch of bureaucrats in a federal agency telling Americans what they can say, what they can tweet, what they can do. I mean, thank goodness we made a big uproar about that and they decided to disband that. I think this is important to think about in the larger context. Who would have ever thought that you would have Donald Trump, Elon Musk, RFK Jr., and Tulsi Gabbard on the same team? And they're on the same team because there is a move by the left to censor Americans. This is, and FTC, what they did to Elon Musk, sent him hundreds of questions. One of the questions they asked him, if you remember, right after he purchased Twitter was, who are the journalists you're talking to? You talk about attack on the First Amendment. That's unbelievable. You're allowed to talk to journalists in America and not be harassed by your government for doing so. So I appreciate the gentleman bringing this forward. We have seen this all over. The guy in Britain who was going after Elon Musk, he just stepped down. Or excuse me, in France, I guess the EU, what was his name, Mr. Breton or something like that? He just stepped down. So this is it. When I've invited in front of this committee or one of the subcommittees to testify RFK Jr., Tulsi Gabbard, Michael Schellenberger, Matthew Taibbi, all Democrats, took heat for doing it. Invited them in, but they came in to speak about the attack on the First Amendment, particularly people's right to speak. What was interesting when we had RFK Jr. in here in front of the committee, Democrats made a motion to kick him out, to go to executive session. He was in to talk about censorship, and Democrats made a motion to go to executive session so people couldn't hear what he had to say. I found that a little somewhat interesting, particularly when his last name was Kennedy. Maybe the most famous name in Democrat politics for, I don't know, 3/4 of a century. You know, RFK Jr. said something in the committee hearing that he also said when he endorsed President Trump. Statement that stuck with me. He said, when you look at history, it is never the good guys who are for censorship. It's always the bad guys. This is what Mr. Rice is bringing forward is a bill that I think makes good common sense where foreign entities are trying to limit Americans' speech rights and impact their business. So I think this is a good piece of legislation. In light of this environment where Homeland Security was established, a disinformation governance board, in light of this overall environment, this is the kind of legislation I think that makes sense. With that, I would yield back to
the gentleman would
sponsor of the
yield.
bill.
I thank the gentleman. I would make for the record that immigration officials already are given the authority to engage in complex analysis such as whether an alien has engaged in terrorist activity, whether he is associated with organizations hostile to the United States, or a totalitarian party. And with that, I would also ask unanimous consent that be placed in the record the now unsealed indictment from Brazil of Facebook, Instagram, Twitter, YouTube, TikTok, and Telegram, and the individuals related to that. Without objection, so ordered.
Would the gentleman yield for a question?
I think you both, have you? Yeah, go ahead.
I've spoken already.
You know what, I'll recognize myself and yield to you.
I just out of curiosity, you mentioned the indictment. Who would be excluded based on that indictment under your provision here from entering the United States?
Could be a decision based on, for example, the judges or officials that led that indictment if it was shown that it stifled the free speech in so doing so.
All right.
I'm not making that claim. And again, understand that all we're saying is that people have no right to come to the United States unless, no, wait a second, it's my time, unless they're American citizens. The ability to come to the United States is a privilege, not a right. And that privilege is withheld for virtually no reason at all in the discretion of the State Department and the United States government, and they do so regularly for a myriad of reasons. The fact is that what we are talking about is simply saying that this is a perfectly good reason. Now, I might note that the First Amendment does speak to religious freedom, and it speaks to religious freedom in a way in which, as a Catholic, I would say the Pope is on good ground to say anything he wants and not have that problem, and he can tell his cardinals to tell the priest anything he wants and not have a problem. Nowhere in this bill would it limit the ability of individuals like that to come. And again, this is a tool when found to be abusive that could be used. I think I'll recognize the full committee ranking member.
Thank you, Mr. Chairman. First, let me just note that the Twitter subpoena that was mentioned earlier was a friendly subpoena and primarily served as a vehicle for Elon Musk to make public 500-plus pages of sealed Brazilian court documents. And I now yield to the gentleman from Maryland, Mr. Ivey.
Thank you. With respect to the larger point, I think it's troubling to suggest that a judge, in this case in Brazil, could be excluded from the United States under no finding that that judge did anything wrong under the laws of his country, Brazil. With respect to an indictment, I don't know how their process works. I don't even know if the judge issued the indictment, maybe. But in absence of some kind of finding of misconduct, I think that's a problem, especially since it's not aimed at having anything to do with the First Amendment in the United States. And by the way, I haven't had a chance to see the indictment. I appreciate the chairman presenting it, but we're still back to the point of who would review that indictment somebody at the State Department, I suppose, to make a determination under the U.S. Constitution that there's a First Amendment violation based on what the indictment does. And to your point with respect to the Pope, I appreciate your view about it, but again, it's not your call to make under your amendment as to whether the Pope telling a bishop you can't talk about X isn't a First Amendment violation. It might be. And the freedom of religion doesn't mean, that means they have the right to, worship in the way that they like. That's different than person X telling person Y under your amendment that you can or cannot say something that he would have the right to say under the First Amendment. Under your express language here, because you don't have an exception for religious freedom or anything along those lines under this language, the Pope could be excluded from the United States based on your language here, just for giving that order with respect to a bishop.
With the ranking
So I would yield back to the ranking member.
I yield to the gentleman.
Thank you. There is a broad waiver authority, which this does not preempt, that the administration always has for certain aliens who would otherwise be inadmissible to the United States. The discretion authority helps alleviate any adverse foreign policy considerations. In other words, the administration, in spite of that action, could admit anyone, and with some regularity, they make those decisions.
Reclaiming my time. The Pope or someone less well-known than the Pope should not have to rely on the discretion of the federal administration for admission to this country. People have legal rights, and under this bill, using as an example the Pope, he would not have a right to enter this country, and one should not rely on the administration. Now, the administration obviously would grant the deferral to the Pope, but not to someone less well-known, and that the administration may never have heard of. So the legislation has to apply to everyone, and it applies in a very bad way, and that's why it's bad legislation. And if Mr. Ivey wants to continue, I'll yield back to him. Then I'll yield back.
We go to the gentleman from California, Mr. McClintock, for 5 minutes.
Thank you, Mr. Chairman. First, I want to thank the ranking member for his remarkable sense of humor, and I certainly appreciate his lightening the mood around here by warning against the impending shutdown hours after he voted against a measure that would prevent a shutdown. But this is no time for levity. On the merits of the bill, I'd suggest that if you can say it on a street corner, you ought to be able to say it on the internet. Even if it is something vile, foolish, false, insulting, the best way to deal with it is to defend the freedom of others, to counter it with something that is wise or true or virtuous, and then trust the American people to be able to tell the difference. And no foreign official should ever be allowed to interfere with this constitutional right of every American to speak freely and without fear. This bill simply says that any foreign officials who try to censor the speech of Americans are not welcome here. We make determinations all the time over conduct that makes an individual inadmissible into our country or removable from our country, as Mr. Ice has pointed out. And that includes such ambiguous terms as moral turpitude. Well, this is a much more specific offense. And what's shocking is the Democrats once fiercely defended the freedom of speech as we did. This was something that we all agreed on. And that seems to be falling apart. Churchill issued a chilling warning to the world when he looked at the dictators in Europe in the 1930s, and he said, you see these dictators on their pedestals surrounded by the bayonets of their soldiers and the truncheons of their police, but in their hearts there is unspoken fear. They are afraid of words and thoughts, words spoken abroad, thoughts stirring at home, all the more powerful because forbidden terrify them. Tiny mouse, a little mouse of thought enters the room, and these potentates are thrown into panic. They are afraid of the workings of the human mind. He went on to say that such a society cannot long endure when brought into contact with the healthy outside world. Well, in case it has escaped my friend's notice, we are the healthy outside world because we have the freedom to speak our minds and express our thoughts without interference from our self-proclaimed betters, whether they live in this country or abroad. And with that, I yield back.
Gentleman goes back. See, oh, Mr. Biggs.
Thank you, Mr. Chairman. And
Gentleman's recognized for 5 minutes.
thank you. I was intrigued by the ranking member's argument because he kept using the word right. The Pope has a right to enter our country. Somebody less well-known than the Pope has a right to enter the country. And so I thought of the chairman and what he said, as he accurately said, it's a privilege. It's a privilege to enter this country. And so I would ask the chairman if you'd intrigue me with this. Does the Pope have a right to enter this country?
No.
Well, I agree with that. And so if you take the argument that was made earlier that I was listening to, is the implication was that you have to show a violation to somebody who's entering this country before you can keep them out. And the reality is we have a myriad of regulations to control that, and we have waivers that allow decisions to be made, but it is nevertheless not a right to enter this country.
Absolutely. If the gentleman would yield just for a moment.
Yes, of course.
You know, we've been talking about some for cause that are very scary, but the most common reason for someone to have a visa denied around the world is based on their likelihood of leaving. That people throughout the world come to the embassy and a judgment call is made by this relatively young embassy staffer that somebody will or will not, at the end of their visiting visa, their student visa, their tourist visa, leave the country. And if they make a determination that they don't have a long enough, a deep enough anchor to their home country, they will be denied. And that sounds harsh, but that is and has been for more than 100 years one of the most important standards leading to it. Yes, on occasions there's some additional items like they're coming to learn how to fly an airplane but not land it. I yield back.
Thank you. And I don't want to belabor the point too much, but I think the bill is common sense, and I associate with myself with most of Mr. McClintock's statements. But with that, Mr.
Would
Chairman,
the gentleman yield just for...
Yeah, I'll yield to you, Mr.
Just one more small comment. We have looked at Brazil, where there's a legal filing that names all of these companies, not just one, and certainly Facebook would probably be one that the Democrats like better than the Republicans. But having said that, the amazing thing is we haven't used the word China once. A place where the government regularly stifles all the free speech, including Americans. So I will tell you that when I was drafting this bill, I was thinking China, even though they have not been named today. I think the examples, public examples, are so much easier because it's Brazil, it's UK, and so on, and we want them to change their behavior. But let's understand, it's about time we start pushing out people such as the Consul General in New York, the Chinese Consul General, who is here today, who was on Facebook day before yesterday, who in fact organized and paid for the beating of American citizens because they were protesting in San Francisco. So yes, I have a lot of examples of wrongdoing that I really want to work on, but yes, this administration has used their decision-making to not enforce when, in fact, everyone on this dais, on both sides, would say that after a Chinese official pays to get Americans beat because they're protesting in America their free speech, they should be pushed out, but have not been. So I thank the gentleman for
Will the gentleman yield?
Yes, I'll yield, Mr. Ivey.
Okay, so it sounds like what you're saying is that foreign officials like President Xi from China, President Erdogan from Turkey, Viktor Orban from Hungary should be excluded from coming to the United States. because they've all made statements along those lines.
So I'll reclaim my time here first. No, I'm going to respond to that. I guess my point would be, what you're insinuating is that they all have an absolute protected right to enter this nation, and I am contesting that. They don't have an absolute right to enter this country, and this bill just points out that. And I'm out of time, so I'll yield back.
Anyone else seek recognition? Seeing none. Okay. The gentlelady is recognized for purposes of offering an amendment.
Thank you. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 9605, offered by Ms. Scanlon. Page 1, after line 3.
The amendment will be considered as read, and the gentlelady is
I'm sorry,
recognized
I'd
to
object.
explain.
I'd like to hear the amendment read.
The clerk will continue.
Insert the following and redesignate the succeeding section accordingly. Section 2, findings. Congress finds the following. 1, this legislation is a continuation of the committee's work throughout the 118th Congress to protect and assist Elon Musk, the owner of X, social media platform formerly known as Twitter. 2, on January 31st, 2023, Mr. Musk met with the new Speaker of the House of Representatives and Chairman of the committee, hereinafter referred to as the Chairman, without any representatives from the minority to discuss the First Amendment and alleged censorship of conservatives. 3, on February 15, 2023, the committee issued subpoenas to Meta, Google, Amazon, Microsoft, and Alphabet. The accompanying letter stated, quote, in contrast to Target big tech company, Twitter recently set a benchmark for how transparent big tech companies can be about interactions with government over censorship, end quote. The committee did not open an investigation into Twitter. 4, in May 2022, Twitter and the Federal Trade Commission, hereinafter referred to as the FTC, entered into a consent decree addressing Twitter's misrepresentations to consumers. Under the terms of that decree, Twitter agreed to submit to continued compliance monitoring by the FTC. 5, on March 7, 2023, on the morning of the Select Subcommittee on the Weaponization of the Federal Government's first Twitter files hearing, the chairman accused the FTC in a report of orchestrating an aggressive campaign to harass Twitter. The chairman's bias for this allegation appears to be the FTC's efforts to enforce the consent decree. 6, on March 10, 2023, the chairman co-authored a letter to the FTC arguing that the FTC made inappropriate and burdensome demands coinciding with Elon Musk's acquisition of the company, end quote. 7, on April 12, 2023, the chairman issued a subpoena and accused the FTC of, quote, abuse of its statutory authorities in investigating Twitter, end quote. 8, on July 5th, 2023, Meta launched a competitor to Twitter, X Corp, known as Threads. On the same day, X's attorney threatened legal action against Meta on July 9. On July 13, 2023, the chairman held an oversight hearing featuring FTC Chair Lina Khan and referred extensively to a motion that Twitter had filed right before the hearing began against the FTC. 10, on July 17, 2023, Chairman Jordan wrote to Meta demanding information and noting that, quote, Threads raises serious specific concerns because it has been marketed as rival of Elon Musk's Twitter, which has faced political persecution from the Biden administration following Musk's commitment to free speech, end quote. On July 25th, 2023, Chairman Jordan threatened to hold Mr. Zuckerberg in contempt of Congress by noticing a markup. 11, on July 17th, 2023, Senator Elizabeth Warren wrote to U.S. Securities and Exchange Commission Chair Gary Gensler asking for him to investigate conflicts of interest relating to Mr. Musk remaining CEO of Tesla while also serving as CEO of Twitter. 12, on July 20, 2023, Twitter served a subpoena on Senator Warren demanding that she produce all documents relating to her communications with the U.S. Securities and Exchange Commission. 13, on July 28, 2023, Chairman Jordan sent a letter to FTC Commissioner Alvaro Bedoya demanding any communications between him and Senator Warren's former chief of staff and Adam Green, quote, another progressive activist aligned with Senator Warren, end quote. 14, on July 18, 2023, Mr. Musk publicly attacked the Center for Countering Digital Hate, herein referred to as CCDH, a nonprofit critical of X's failure to address disinformation and hate speech on its platform. Mr. Musk called its CEO, Imran Ahmed, a quote, rat, end quote, and asked who is funding this organization. They spread disinformation and push censorship while claiming the opposite, truly evil, end quote.
Mr. Chairman, well, I'm going to reserve a point of order which will allow the clerk a moment to just take a breath before she continues. It's 8 pages. Yeah, that's why I'm reserving now. Give her just a break, drink of water, breath, all that.
15, on July 20th, 2023, the Select Subcommittee on the Mobilization of the Federal Government held a hearing featuring Robert F. Kennedy, Jr., identified by the CCDH as one of the 12 most prolific spreaders of COVID-19 related misinformation. Almost as soon as hearing concluded, X wrote to CCDH accusing it of trying to hurt its advertising business. On August 1st, 2023, X sued the CCDH. On August 3rd, 2023, Chairman Jordan wrote to CCDH requesting broad swaths of documents. 16, on March 25th, 2024, a federal judge dismissed Twitter's lawsuit against CCDH, writing that, quote, this case is about punishing CCDH for their speech. 17, on June 25th, 2024, the chairman forced CCDH CEO Imran Ahmad to appear for a transcribed interview before the committee where Ahmed confirmed that CCDH's reports are an exercise of its free speech. 18, on May 5th, 2023, the chairman subpoenaed officials from the Global Alliance for Responsible Media, hereinafter referred to as GARM, and the World Federation of Advertisers, hereinafter referred to as WFA, for documents and communications related to their coordinated efforts to demonetize and censor disfavored speech online.
The clerk will pause. If you'd please take a drink of water. You're becoming, I think, hard to speak, and I don't want to exhaust your valuable ability to do so. Take the time you need. We're not in a hurry. The clerk can continue at her own discretion.
18, on May 5th, 2023, the chairman subpoenaed officials from the Global Alliance for Responsible Media, hereinafter referred to as GARM, and the World Federation of Advertisers, hereinafter referred to as WFA, for documents and communications related to the coordinated efforts to demonetize and censor disfavored speech online. 19, on July 10th, 2024, the majority released an interim report on GARM's efforts to, quote, control online speech, end quote. This effort specifically claims that GARM directed its members to boycott Twitter after Elon Musk acquired the company, although Rob Wackowitz, the leader of GARM, denied having done so in his transcribed interview before the committee. A GARM member documented discussions about the boycott, noting that the company had pulled advertisements from Twitter based on GARM's recommendations. 20. Recently, X refused to obey court orders by Supreme Court Justice Alexandra de Moraes, who shut down the company's presence in the country and also imposed massive fines. The chairman has involved the committee by writing to Federal Bureau of Investigation Director Wray, requesting a briefing from the State Department, and even put out 2 slanted reports publicly releasing what had been sealed orders by Justice Moraes. 21. The committee has also become involved in a dispute between Mr. Musk and the European Commission. On August 12, 2024, then Commissioner Thierry Breton wrote a letter to X regarding then upcoming broadcast planned on X's platform in the context of compliance with the European Union's Digital Services Act. Mr. Musk responded by sharing a meme that invited Commissioner Breton to, quote, take a step back and literally expletive your own face, end quote. This exchange prompted the chairman to send multiple letters accusing Commissioner Breton of censorship. 22. In July 2024, the New York Times reported that Elon Musk is backing, quote, American PAC, end quote, a political action committee which intended to spend as much as $160 million to help Republican presidential candidate Donald Trump and Republican down-ballot candidates. 23. In August 2024, the Wall Street Journal reported that Elon Musk's goal is to turn out 800,000 people to vote for Donald Trump in battleground states. 24. On August 12, 2024, Elon Musk interviewed Donald Trump on the X platform. 25. This week, Mr. Musk's super PAC, American PAC, is spending more than $2.1 million across 14 competitive House races and has set aside $10 million for voter turnout in House races across the country. 26. On September 5th, 2024, Donald Trump said that if elected, he would place Elon Musk in charge of a government efficiency commission. 27. On September 15th, 2024, following an assassination attempt against Donald Trump, Elon Musk tweeted, quote, "and no one is even trying to assassinate Biden/Kamala," end quote, punctuating his sentence with a thinking face emoji. Musk later deleted his tweet.
Mr. Chairman, I'll withdraw my point of order.
Any other objections? Never mind. The gentlelady is recognized to, I guess, further explain her amendment.
Thank you, and I want to thank staff for reading the amendment. In the absence of any legislative hearings or other regular process, there are limited opportunities for the minority to flesh out the facts and the records behind this bill. So first and foremost, I have to state the obvious, because apparently it's not obvious to my colleagues across the aisle. While this committee wastes time and resources considering a poorly drafted bill to placate Elon Musk, our government is going to shut down in 11 days. That means federal agencies will stop operating, millions of workers won't see their paychecks, struggling families won't be able to access childcare, sick Americans will lose access to health care, essential benefits like food stamps will be interrupted, Medicare enrollment will halt, and so much more. It appears our colleagues across the aisle have become desensitized to the harms of government shutdowns because of how often they're willing to hold Americans hostage until their political goals are met. Over and over and over again, we've seen these headlines. A shutdown looms because Republicans refuse to pass a budget. So just want to remind our colleagues, since Democrats don't have the benefit right now of being in the majority and setting the agenda, keeping this country going, keeping it funded is our core responsibility in this chamber. But instead of heeding that responsibility, we're here again, holding a markup to protect a single billionaire who thinks that the U.S. government should pervert the law to serve him. It's ludicrous, and certainly not what the American people elected us to do. But since the majority deems this bill of such importance, I think we need to take a moment to dive a little bit deeper into this bill and what this committee has done this Congress. This amendment lays out exactly that, how this committee has spent its time and resources to protect Elon Musk. Twitter has received special treatment and been functionally exempt from the committee's investigation into big tech, which did include Alphabet, Amazon, Apple, Meta, and Microsoft. Musk met behind closed doors with the chair of this committee and the Republican speaker without Democrats being invited or present. Chairman Jordan has publicly attacked federal agencies like the FTC and U.S. senators for daring to hold Twitter, or I guess X at this point, accountable to U.S. laws. The committee went after Meta for daring to create a competitor to the company formerly known as Twitter when Meta launched Threads, and it interfered in the company's right to engage in the free market. The committee has launched investigation after investigation predicated on conspiracy theories to protect Mr. Musk and his company. I'm limited to 5 minutes here, so I can't get into all of the details, but these examples are the tip of the iceberg. So now we're marking up a bill that is a thinly disguised measure to protect this one single billionaire from losing ad revenue. Once again, Musk seems to be dispatching members of this committee to protect him and clean up his messes. It's outrageous. And are we supposed to believe it's a coincidence that this protection comes after Elon Musk pledged $45 million a month to Trump's campaign? Or that it's irrelevant to Republicans that he's working to deliver 800,000 voters to Trump in November? Irrelevant that he's elevating the Trump campaign's bogus claims and vile conspiracy theories on his social media platform? And are we supposed to believe it's a coincidence that this committee jumps to protect Elon Musk as he pours tens of millions of dollars into competitive House races supporting far-right candidates? This isn't good governance. The American people elected us to work for them, not erratic billionaires who are pumping millions into MAGA campaigns, to solve issues like the rising cost of housing and education, to prevent gun violence, to provide medical care, to build better infrastructure worthy of the 21st century, and to help American families put food on their tables. That's what we're supposed to do here, not put Congress's thumb on the scale for billionaires like Elon Musk. If people plan to vote for this outrageous bill, I hope they will at least accept this amendment that lays out the history and truth behind this, how this legislation came to be. The American people deserve to know that. I would seek unanimous consent to introduce 2 articles. The first is Elon Musk PAC is spending millions to keep GOP in control of the House. That's from September 17th in Business Insider.
Without objection.
In the second article, Elon Musk boosts fake Trump rally bomb threat and false claims about the election. That's a CNN article from September 18th, 2024.
Without objection, so ordered.
Thank you. I yield back.
I thank the gentlelady. I'll recognize the chairman of the full committee.
Well, thank you, Mr. Chairman. Just a couple thoughts. I don't have time to go through all 27 things in this amendment, which I strongly disagree with. Just let me a couple points. One of the first points made in the amendment was we didn't subpoena X. Well, you know why we didn't subpoena X? Because they gave us the Twitter files, because they told us what was going on. And we did subpoena some of the others, of course. And guess what? They were censoring Americans. You don't have to take my word for it. Mark Zuckerberg wrote us a letter, wrote this committee a letter, and told us he was censoring Americans. And guess what he said? He said, I censored Americans because the Biden-Harris administration pressured me to censor Americans. He said he wished he hadn't done it. He's going to try not to do it in the future. He said they actually worked on suppressing the Hunter Biden laptop story that happened in October 4 years ago, before the most important election we have. I'm actually very proud of the work this committee has done to protect the First Amendment. I'm proud of the fact we invited in, as I said earlier, all kinds of Democrats to testify in front of this committee. Democrats who came in who respect the First Amendment. GARM, the organization cited in the gentlelady's amendment, they discontinued operations after we exposed the censorship operation they were colluding in and doing. Commissioner Breton is mentioned in the amendment. He just stepped down last week after we uncovered the censorship operation he was promoting. So I'm proud of the work of this committee. And this attack on First Amendment free speech rights, I think, is frightening. I think it's scary. So I appreciate Chairman Issa and the work he's doing in this legislation. Yield back the balance of my time to the chair.
Gentlemen, if you'll yield to the chair, I'll just ask unanimous consent that in addition to the amendment being considered, that the amendment be added to the opening statement material at large. Without objection, so ordered. Does anyone else seek recognition? The gentleman from Maryland is recognized to strike the last word.
Thank you, Mr. Chairman. I guess I'll take the bait on this. We've had a variety.
I'll note to the gentleman, I'm happy for us to just go to the previous question. There's no intent to bait anyone.
I wish you'd said that before the full committee chair made his comments, but I appreciate that, Mr. Chairman. Look, we've had a discussion here in the Judiciary Committee and the Homeland Security Committee about this issue. I think, and the one I remember here in this committee was a focus on, I want to say it was a district court ruling. I'm sorry, I didn't know we were going to go down this rabbit hole. I would have brought it. And I remember the chairman reading extensively about how that district court judge had found all kinds of censorship and misconduct by the Biden administration and the social media platforms. And I want to note that all of that language was thrown out, actually, when it went up on appeal. And there was a finding also that a lot of the factual findings the district court had made in support of the comments that were, the type of comments that were made by the chairman, were rejected as being false. So that's number one. Number two, for this committee, I got to go back to Nina Jankowicz, who was briefly appointed to run the entity in the Homeland Security effort that was aimed at addressing disinformation and false information. She basically got run out of the government, I apologize, by comments that were made by members of this committee online. So you want to talk about impacting someone's, not just First Amendment rights, but rights to live. She ended up having to get personal security to protect her, because after the members made those comments online, people started coming after her. She hired personal security. They told her that she needed to change her address and move. She went to, she was pregnant at the time. She went to see her OBGYN. She had to go in disguise in order to avoid the harassment and the risk that was created by the comments that were made that I thought were unfounded. And, you know, she testified about that before this committee in one of the interviews that was conducted. It was recorded. I don't know if it's ever been made public, but, you know, certainly that incident's been made public too. So, you know, Mr. Chairman, I guess we can disagree on the factual basis for what you're talking about. I'll say this, though, just as a quick reminder. We've got an election coming up, and I know there's disputes about what's happened in previous elections, but it's very clear that adversary countries, Russia, China, Iran, are making complete efforts to have an impact on our elections, presidential and otherwise, using disinformation, false information, and misinformation online. And we no longer have any mechanism in place at the federal government level to defend against that. So, you know, you got what you wanted, I suppose, in some respect. This might be one of those unintentional consequences, but we are clearly not prepared to address that. Not at all. So with respect to this particular amendment, you know, let's at least be clear about what the intention of the legislation is behind it. But, and we've talked about some of the particulars, the substantive issues, and, you know, who can get deported, who doesn't. I think the impact on the State Department and diplomacy with respect to the United States of America, without having anybody from the State Department come in here and talk about the potential implications, is ridiculous, especially in the context of, we talked about the Pope, we talked about different foreign leaders and all that, and you know, you're saying they may be exempted or there's a waiver. The language in this amendment says any alien. Doesn't talk about any kind of waiver or anything like that. It says any alien, and it also says there's inadmissibility, but there's also deportability. So under this provision, somebody who's here, a foreign dignitary, leader of another nation, could be deported based on the statements that they're making under the provision you've got here. And I just think it's astonishing that we would put together legislation that could lead to that kind of result. I mean, do we need that kind of international incident without consulting with anybody who has any kind of work or role or expertise in dealing with those sorts of things? The world's a dangerous place right now. I don't think we need to layer this kind of thing on top of it. And with that, I'm out of time. I yield back.
For what purposes, gentlemen from, what can we do, New Jersey? New Jersey seek recognition.
Thank you, Mr. Chairman. I think I'll be relatively quick here. I like to
recognized for 5 minutes.
Thank you. I'd like to get down to basics. First of all, just a few of the points that were made in that amendment. I respect the lady who presented the amendment, but I disagree with the amendment thoroughly. Elon Musk, when folks didn't know what political persuasion he was, or even folks thought maybe he was a Democrat, multi-billionaire, everybody loved him. Everybody loved him on the Democrat side. Great guy, the electric cars, innovation, all the things that he did. Now that we find out that he tends to be more of a conservative Republican and a believer in freedom of speech, he's a horrible, awful, terrible man. I would maintain it's not because of anything that has changed in what he has done or what his companies represent, but it's because now he's a conservative and a Republican. It's the same with Bobby Kennedy. Kennedy family, a great family in Democratic politics. But Bobby Kennedy Jr., it turns out that he just couldn't hack it anymore, and he spoke out, and now he's a horrible, terrible, awful man. If he had stayed a Democrat and toed the line, he would have been a wonderful man. And suddenly, my colleagues on the other side, and you only bring this up because it was brought up in the amendment, going after Elon Musk. Now, Democrats are great fans of Liz and Dick Cheney. Dick Cheney, holy cow. Sometimes Dick Cheney scared me. Wow. And as the chairman so rightly pointed out, Mark Zuckerberg was clear. He is a Democrat, but he is ashamed of what happened when he was forced to censor certain things, not to allow freedom of speech on his platform. He came forward with that finally. In the beginning, it was reluctant, but he did. Freedom of speech is so damn important. It's everything that this country is based on: freedom of speech, freedom of religion, freedom to do what you want to do. And that has been lost to some degree on some people, unfortunately, on the other side. And then finally, it was brought up, and I just wanted to go through these one by one. My good colleague from Maryland, Russia, China, Iran getting involved in the election. I got to tell you, Russia, China, and Iran are not for Donald Trump. Believe me, they're not. So I guess the bottom line I would say is I would urge my colleagues not to support this amendment just on that very basic, the basic premises that I bring up. I mean, to me, this is just not factual information. And, you know, I see the irony of it, and even during these difficult times, I see the humor of it. But in reality, this is a serious bill, it's a serious issue, and I think we should support the bill and certainly not support this amendment. And with that, Mr. Chairman, I yield back.
Would gentleman yield? Gentleman
Yes, I yield to the gentleman from Ohio, our chairman.
I thank the gentleman for yielding. The gentleman from Maryland mentioned foreign entities trying to involve themselves in our election process, which we're all against. But I would just point out, this is a story, I think it's from the Rolling Stone, and was confirmed, I think, yesterday. But Trump campaign's 271-page dossier on J.D. Vance was hacked by Iran. Now, Iran just didn't hack something from the Trump campaign. What did they do with the information? Reported yesterday, they gave it to the Biden campaign. Now, this is something I'd like to know about. Who'd they give it to? How long did the Biden campaign have it for? I mean, there's all kinds of questions we need to know there. So yeah, we don't want foreign involvement in our election process, but the one thing we know that's happened thus far has been reported is Iran hacked the Trump campaign information on vice presidential candidate, United States Senator from our great state, J.D. Vance, and that information somehow found its way to the Biden campaign. I think there's all kinds of information we need to figure out about that, all kinds of questions. Who got it, how long they have it, when the FBI know about it, what was going on, all those things we need to know. That's something that this committee, I think, should be digging into, and we plan to do that. With that, I thank the gentleman for yielding and yield to the chair.
The gentleman yields back. The gentleman from Arizona seek recognition.
Thank you.
The gentleman's recognized for 5 minutes.
I appreciate that. I weighed into this argument with some trepidation, but I would just point out a couple things about the amendment in and of itself. Page 6, line 9, does not indicate what country the Supreme Court Justice Alexander de Moraes is from. I think that's necessary if you're going to have a complete and accurate record. But then we get to this whole series of things right toward the end that there's money going to different Republican candidates, apparently. I'm not seeing any of it, I can guarantee you that. But what I will tell you is this. It imputes a motive here, and it imputes something that's would really be wrong, and that is an ethical violation. You cannot question motives, and that's what this does. It's a surreptitious way to get around the ethics rules here. But I just bring that up because I think it's unfortunate that happened. But I thought I would just mention, since you're harping on Elon Musk, and I just can't help but think of George Soros, your favorite sugar daddy for the Democrat Party, who since January 2020 through January 4th of 2023 had given roughly $500 million through multiple Open Society Policy Center, multiple organizations called Open Society University Network, Open Society Foundations Network, $500 million. As this article says, largely toward political causes aligned with the Democrat Party. And then going on through, you'll see that it's going to largely to Democrat candidates. I just think that's interesting as heck. Interesting as heck. And, you know, Mr. Chairman, I requested this article for, entitled "The Formula for Success," nonprofit financed by billionaire George Soros quietly donated $140 million to political causes, be admitted into the record.
Without objection.
Thank you. And I think that what this amendment did was an attempt to sully everybody, the sponsor of the bill, the chairman, this committee, and I think that that is really not the way this committee needs to go. We have enough problems without trying to impute unethical conduct and pecuniary bias. That really crossed the line, in my opinion. And that's a huge problem. If you don't like this bill, have at it, for Pete's sakes. We do that all the time, but I think the line was crossed here, Mr. Chairman, with the yield back.
The gentleman would yield.
Gentleman yields.
The gentleman yield. I would ask, as the acting chair here, that we all return to speaking on the merits of the bill to the greatest extent possible. That has been a long tradition of this committee, and there are plenty of things to say as to the merit. I can't enforce that, but I would ask all our colleagues to do so, because I believe that the issues that are genuinely being talked about, which is the First Amendment, are worthy of exactly that. Does anyone else seek recognition? Seeing none, the question is on the amendment to the amendment in the nature of a substitute.
No.
Once again, the question occurs on the amendment offered by the gentlelady from Pennsylvania, and I'd ask all those in favor say aye.
Aye.
Any opposed say no. No. In the opinion of the chair, the noes have it.
Recorded vote.
The gentlelady requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Sparks? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Ruley? Mr. Ruley votes no. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivey?
Aye.
Mr. Ivey votes aye. Ms. Ballant?
Aye.
Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye.
The clerk will report.
Mr. Chairman, there are 7 ayes and 11 noes.
The noes have it. The amendment is not agreed to. The question is now on adopting the amendment in the nature of a substitute. This will be followed immediately. The gentleman has a UC request. He's recognized.
Yes, thank you, Mr. Chairman. I just wanted to offer, I believe this is the letter that the chairman referenced. from Mr. Zuckerberg to Chairman Jordan dated August 26, 2024. I'd like to offer it.
It will be offered without objection, so ordered.
Thank you.
The question is now on the adoption of the amendment in the nature of the substitute. This will be followed immediately by a vote on reporting the bill. All those in favor of the amendment in the nature of a substitute, say aye. Aye. Any opposed? No. In the opinion of the chair, the ayes have it, and the amendment is agreed to. The question now is on favorably reporting the bill as amended. All those in favor say aye. Aye. Any opposed?
No. No.
In the opinion of the chair, the ayes have it, Mr. Chairman. The gentleman requesting a recorded vote? Do indeed. Then the clerk will call the roll.
Mr. Jordan. Mr. Jordan votes yes. Mr. Issa.
Yes.
Mr. Issa votes yes. Mr. Gates. Mr. Biggs. Mr. Biggs votes yes. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Massey votes aye. Mr. Roy. Mr. Bishop. Ms. Sparts. Mr. Fitzgerald. Mr. Benz. Mr. Benz votes aye. Mr. Klein. Mr. Armstrong. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes aye. Mr. Kiley. Ms. Hageman. Mr. Moran. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Fry votes aye. Mr. Ruley. Mr. Ruley votes aye. Mr. Nadler. Mr. Nadler votes no. Ms. Lofgren. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Swalwell votes no. Mr. Liu. Ms. Jayapal. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes no. Mr. Neguse. Ms. McBath. Ms. Dean. Ms. Dean votes no. Ms. Escobar. Ms. Ross. Ms. Ross votes no. Ms. Bush. Mr. Ivy.
No.
Mr. Ivy votes no. Ms. Ballant. Ms. Ballant votes no. Mr. Garcia. Mr. Garcia votes no. Mr. Fitzgerald votes aye.
How is Mr. Massey recorded?
Mr. Massey is recorded as aye.
How is Mr. Duarte reported? No, never mind.
Mr. Chair, how am I?
Mr. Moran, how are you recorded?
Mr. Moran, you are not recorded.
Aye.
Mr. Moran votes aye. Mr. Van Drew, you're not recorded. Mr. Van Drew votes yes. Ms. Escobar votes no.
How is Mr. Gates reported?
Mr. Gates is not recorded. Mr. Gates votes aye. Mr. Gooden votes yes.
Gentleman from Virginia.
Mr. Klein votes aye.
Where are we at here? Clerk will report.
Mr. Chairman, there are 16 ayes and 9 noes.
The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Okay. 358. The chair now recognizes, pursuant to notice, I call up H.R. 358, the Small Business Regulatory Flexibility Improvements Act, for purpose of markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 358 to amend Chapter 6.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Virginia, Mr. Klein, for an opening statement.
Thank you, Mr. Chairman. The Small Business Regulatory Flexibility Improvements Act is an important piece of legislation that will help American small businesses comply with the overwhelming weight of federal regulation. Small businesses around the United States are at a disadvantage when complying with such regulations. They include one-size-fits-all rules that raise prices at the cash register, cause significant economic harm to small businesses as well as consumers. Burdensome regulations also can keep some small businesses out of the market altogether. Facing insurmountable compliance costs, potential entrepreneurs all too often choose to never open their small business in the first place. Under the existing Regulatory Flexibility Act, known as the RFA, agencies that issue economically burdensome regulations are required to take small businesses into account. However, all too often, agencies don't comply with the RFA's mandates. While the RFA requires agencies to study the effect of the regulations have on small businesses, in up to 75% of rulemakings, the agencies either ignored costs on small businesses or underestimated the regulations' cost, according to NFIB. H.R. 358, Small Business Regulatory Flexibility Improvements Act, would strengthen the RFA's already existing provisions and deter agencies from skirting their statutory obligations to American small businesses. It requires that agencies convene small business review panels when promulgating all major rules, which gives small businesses a seat at the table to voice their concerns about the economically harmful regulations. It also requires that regulators take the indirect cost of the regulations into account. As my colleague, the gentlelady from Wyoming, pointed out last time we debated amendments to the RFA, the bulk of the harm from regulations comes from the indirect cost of compliance. This bill addresses the oversight in the federal regulatory process. Further, it authorizes the Small Business Association's Chief Advocacy Council, Small Business Administration's Chief Advocacy Council to create rules mandating how agencies must conduct their analyses. Finally, it mandates that all rules as defined under the Administrative Procedures Act, not just notice and comment rulemakings, are covered by the RFA's analysis requirements. The RFA was passed in 1980, but there are still agencies which do not take the specific needs of small businesses into account when crafting regulations. Unfortunately, federal regulators have failed in their obligation to American small business owners under the RFA. This bill is a common-sense effort to ensure regulators comply with the RFA's provisions as Congress intended by fully considering the total regulatory impact on small business owners when crafting legislation. I urge my colleagues to support the bill, and I yield back.
Chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, everyone on both sides of the aisle agrees on the need to support small businesses. Federal agencies are already required to consider the effects of their regulations on small businesses under the Regulatory Flexibility Act, or RFA. H.R. 358, however, turns this reasonable requirement into a never-ending hall of mirrors. It would impose burdensome new requirements on agencies that would lengthen and complicate the rulemaking process, exposing businesses of all sizes to nearly constant regulatory uncertainty and posing grave risks to public health and safety. A few provisions of the bill illustrate just how heavy-handed these new requirements are. First, the bill requires agencies to submit their rules to an interagency review process and to elicit public feedback before they've even published them in the Federal Register. This requirement applies to all agencies and virtually every rule that results in any increased costs, far beyond the requirements of the current RFA. Second, the bill repeals the authority that agencies have under the current RFA to waive or delay the law's requirements when issuing a regulation in response to an emergency. This senseless provision prevents agencies from doing their job properly and directly jeopardizes the health and safety of the American people. Third, the bill would vest expansive new authority over the entire federal rulemaking process in a single official, the Chief Counsel for Advocacy at the Small Business Administration. As I noted earlier this year when the committee marked up the Prove It Act, which also gave new powers to the Chief Counsel, placing this level of power in a single office that has not had a permanent director since 2017 is strange, to say the least. Finally, on top of all these new burdens on the rulemaking process, agencies would be under constant threat of judicial challenge. Given the expansive nature of the new requirements the bill imposes, virtually any well-resourced litigant could claim some basis for hauling an agency into court and grinding the rulemaking process to a halt. Wealthy private parties already use the court system to block the implementation of rules. There is no need to give them another cudgel to use against our public agencies and their enforcement of the laws Congress made. Ironically, a bill that seems so preoccupied with supposedly overbearing power of the administrative state would likely require agencies to hire many new lawyers and other staff just to perform all the additional work the bill requires of them. Without these additional resources, agencies would likely struggle to enact their regulatory agendas. For our Republican colleagues, of course, this is precisely the point. In sum, while this bill claims to be about helping small businesses, it is just another front in the Republicans' war on good government. Coupled with the Supreme Court's recent decisions overturning the precedent of Chevron deference to public agencies and undermining the statutory time limit on challenging rules, the bill illustrates the shape of the Republicans' giveaway to big corporations and their wealthy allies, making it easier for them to sue government agencies with one hand and then stacking the deck in their favor in the courts with the other. If Republicans were serious about helping small businesses, they would join Democrats in protecting a level playing field in the marketplace. This bill does nothing to further that goal, and I urge my colleagues to join me in opposing it. I yield back.
Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Virginia for the purpose of offering an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment in the desk.
Clerk will report.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from Virginia to explain the amendment.
Mr. Chairman, this momentous amendment adds of 2023 to the title of the bill. This change is not intended in any way to alter the important purpose of this bill. I urge support for the amendment, and I yield back.
Gentleman yields back. To who seeks recognition?
Mr. Chairman, I have a UC request.
The ranking member is recognized.
Mr. Chairman, I ask the unanimous consent to enter letters from the Coalition for Sensible Safeguards and the Earth Justice opposing the bill.
Without objection. The question is on the adoption of...
Mr. Chair.
The ranking member is recognized. The gentleman has an amendment. Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 358 offered by Mr. Nadler of New York. Page 25, insert after line 19 the following, and conforms...
Objection. The amendment will be considered as read. The gentleman from New York is recognized to explain his amendment.
Thank you, Mr. Chairman. I will not demand the entire bill be read. Mr. Chairman, my amendment would provide that when a court reviews an agency's compliance with the provisions of this bill, it must defer to the agency's factual findings with respect to whether a rule will have a significant economic effect on a substantial number of small entities. The Supreme Court's recent
Gentleman, hold
decision
for just a second. Gentleman from Wisconsin.
I reserve a point of order.
Point of order is reserved. Gentleman, continue.
The Supreme Court's recent decision overturning the doctrine of Chevron deference to our public agencies shows that the right-wing supermajority in the court is willing to expand its own power at the expense of the American people and of their representatives in Congress. Congress has the power and the responsibility to push back against this brazen power grab by clarifying the role of courts when construing delegations of authority to federal agencies. This bill provides us with a limited opportunity to begin doing that important work. The Regulatory Flexibility Act, as amended by the bill under consideration today, leaves it to each federal agency to determine if the rule it promulgates will have a significant economic impact on a substantial number of small entities. The agencies themselves are in the best position to measure and describe the economic impact that their regulations will have, and courts should respect that. This amendment respects the proper separation of powers under the Constitution and would ensure that courts reviewing challenges to agency action under this bill will defer to the agency's judgment on this question and not second-guess their factual findings. I ask that my colleagues support the amendment, and I yield back the balance of my time.
Gentleman yields back. The chair recognizes the gentleman from Virginia for 5 minutes.
Mr. Chairman. I oppose the amendment and urge my colleagues to also oppose it. The amendment would...
Gentleman yield. Just for 1 second.
I remove my point of order, Mr.
On his point of order, the gentleman is recognized from Virginia.
Mr. Chairman, to be clear, the only power that this bill authorizes is for the SBA to establish rules dictating how regulatory agencies must comply with the RFA. It doesn't in any way authorize the SBA to review the substantive policy of any regulation. So this amendment would go far beyond the scope of the bill, and I would urge my colleagues to oppose it.
Gentleman yields back. The question occurs on the amendment to the amendment in nature for substitute offered by the gentleman from New York. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman, I ask for a recorded vote.
The gentleman requests a recorded vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Mr. Moran votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Ruley? Mr. Ruley votes no. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Mr. Fitzgerald? Mr. Fitzgerald votes no.
Gentleman from California?
Mr. Isa votes no.
Clerk will report.
Mr. Chairman, there are 7 ayes and 15 noes.
The noes have it. The amendment is not agreed to. The question occurs on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair is the ayes have it. The amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it.
Mr. Chairman, I ask for a recorded vote.
Gentleman requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Isa votes yes. Mr. Gates? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes yes. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Ruley? Mr. Ruley votes aye. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Swallow votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no.
Clerk will report.
Mr. Chairman, there are 17 ayes and 7 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. I would just let the committee members know that we have 2 pieces of legislation to be considered yet. We're going to take a brief recess. We're working on ironing out one little amendment to the Victims of Terrorism Compensation Act. And so we'll take a brief recess, and we'll be back, I'm hoping within a half an hour. So the committee will stand in recess. Yep. 44, providing for congressional disapproval under Chapter 8 of Title 5, United States Code, of the rules submitted by the Bureau of Alcohol, Tobacco, Firearms, and Explosives relating to definition of, quote, engaged in the business as a dealer in firearms for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the resolution.
HJ Res 144, providing for congressional...
Without objection, the resolution will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Kentucky, Mr. Massey, for an opening statement.
I thank the chair. This resolution seeks to protect the rights of law-abiding gun owners and collectors by nullifying the Bureau of Alcohol, Tobacco, and Firearms and Explosives rule about what constitutes being, quote, engaged in the business, unquote, of dealing firearms to require an individual to obtain a federal firearms license. The resolution disapproves the rule and ensures it has no force or effect. For more than a decade, Congress has rejected legislation to require a background check for nearly all transfers of a firearm. However, in March 2023, President Biden issued an executive order that the White House described as directing the Attorney General to, quote, increase the number of background checks conducted before firearm sales moving in the U.S. as close to universal background checks as possible without additional legislation, unquote. In other words, the Biden administration was making new laws without congressional authorization. Democrats want to regulate firearm transfers between close friends and, in some cases, family members. Requiring more casual transfers of firearms to get a federal firearms license, an FFL, will mean that those individuals will be required to undergo background checks. On September 8, 2023, ATF began its effort to regulate the lawful private sale of firearms by publishing a notice in the Federal Register. The resulting rule drastically expands the universe of Americans who would be classified as a, quote, dealer under the federal law that requires some people to obtain a license to become a federal firearms licensee. Under federal law, an individual who willfully engages in the business of dealing in firearms without a license is subject to a prison term of up to 5 years and a fine of up to $250,000 or both. As justification for its overreach, ATF cited the Bipartisan Safer Communities Act, which was signed into law in 2022 and made minor definitional changes in the relevant firearm statutes. As justification for its overreach, ATF cited, the BCSA modified the statutory definition of engaged in the business of dealing in firearms to remove the requirement that a person's, quote, principal objective, unquote, must include both, quote, livelihood and profit, unquote. In its final rule, ATF relies on this slight modification to draw the conclusion that, quote, even a single firearm transaction or offer to engage in a transaction, when combined with other evidence, may be sufficient to require a license, unquote, as an FFL. Think about that. Selling one gun makes you engaged in the business of selling firearms. Sounds ridiculous to me. Or not even selling the firearm, but offering to sell the firearm would make you a dealer. However, the BSCA did not remove, and ATF's proposed rule largely ignores, the provision in the statute stating that the term engaged in business shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. In fact, even the lead Republican co-sponsor of the BSCA, Senator Tillis, opposes this rule and introduced the Senate companion to this legislation. In doing so, he stated, quote, this overreach is exactly why Republicans don't trust this administration, and it will set back any attempt on future bipartisan legislation as long as President Biden is in office. I encourage my colleagues to support this Congressional Review Act we introduced and immediately overturn this ridiculous regulation, unquote. It's clear that the ATF's rule goes beyond the agency's statutory authority to create several presumptions about when an individual is engaged in the business of dealing in firearms, which would require them to register as a federal firearm licensee, FFL, under federal law. However, when passing the Gun Control Act of 1968, Congress did not include any of these presumptions. The rule states that, quote, absent reliable evidence to the contrary, unquote, individuals are presumed to be engaged in the business of dealing in firearms if their conduct falls within one of ATF's specified categories. In other words, the rule flips the burden of proof and presumes that Americans engaged in conduct in violation of the law, that they're engaged in this conduct unless they can prove their innocence. This is ridiculous. It goes against over 200 years of jurisprudence in this country that you are innocent until proven guilty. This rule requires that you are guilty until you can prove your innocence. This resolution that we're proposing here will nullify the rule pursuant to the Congressional Review Act and will prevent regulatory overreach by ATF, ensuring that existing laws that govern firearms sales are not expanded without proper legislative authorization. This resolution also addresses the ongoing issue of the Biden administration's repeated misuse of rulemaking authority to infringe upon Americans' fundamental right to keep and bear arms. Thank you, and I yield back.
Gentleman yields back. I now recognize the ranking member for his opening statement.
Mr. Chairman, last year, over 40,000 Americans died from gun violence. That's more than 100 Americans every day. This figure includes countless parents, grandparents, sons, daughters, friends, mentors, and spouses. It includes victims of hate crimes, domestic abuse, terrorism, and violent crimes, innocent bystanders, and those who died trying to protect someone else. From the recent school shooting in Georgia to the shooting at Trump's own campaign rally in Pennsylvania, to incidents of violence that do not make the headlines, we continue to lose more than 100 Americans every day because it is far too easy for dangerous individuals to access a firearm. Too many of my Republican colleagues are content to let this epidemic of gun violence continue unabated. But as members of Congress, we have a choice. We don't have to stand by while tens of thousands of Americans lose their lives to gun violence. We can choose to change our nation's laws to reduce gun violence and save lives. 2 years ago, that is what every single Democratic member of the House and Senate, as well as 29 of our Republican colleagues, chose to do. We voted in favor of the Bipartisan Safer Communities Act, the first significant gun violence prevention law to be enacted in nearly 30 years. Among the law's many measures to make our communities safer was a provision requiring more people who sell guns to obtain a license and to conduct background checks. As a result of our choice to take decisive action to protect our constituents from gun violence, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, was required to update its regulations to conform with the changes we made to the law. And in April, the ATF issued a final rule implementing the Bipartisan Safer Communities Act and clarifying who must obtain a license to sell firearms. But faced with the staggering number of gun deaths we see year after year, Republicans today are making a different and very troubling choice. Rather than working with us to make our communities safer, they are actively standing in the way of efforts to prevent gun violence by seeking to repeal the ATF's rule implementing the law that we passed just last year. Along the way, they are waging a disinformation campaign about the drivers of gun violence, about law enforcement efforts to stop criminals, and about the laws we know will save lives. Today, they continue that campaign. They will say that the ATF is exceeding its authority, but they know that the ATF was required to update its regulations to align with the mandate we gave them when we passed the Bipartisan Safer Communities Act last year. They will say that this ATF rule will target hobbyist gun sellers, but they know the rule explicitly says, quote, individuals who purchase firearms for the enhancement of a personal collection or a legitimate hobby are permitted by the Gun Control Act to occasionally buy and sell firearms for those purposes or occasionally resell to a licensee or to a family member for lawful purposes without the need to obtain a license, end quote. They will say this ATF rule violates Americans' Second Amendment rights, but they know that the rule expressly says, quote, nothing in this rule shall be construed as precluding a person from lawfully acquiring a firearm for self-protection or other lawful personal use, end quote. They will say that this rule will be used to prosecute innocent people, but they know that ATF Director Stephen Dettelbach testified before this committee in May that, quote, The most common type of firearms trafficking now is dealing firearms for profits without a license, and that 60% of trafficked firearms go to convicted felons and prohibited people, and thousands of these trafficked guns are used in murders and shootings, end quote. Republicans won't tell you what we all know to be true. The Bipartisan Safer Communities Act and the ATF's rule that they are seeking to repeal is already making all our communities safer by reducing the number of guns sold to domestic abusers, those convicted of violent crimes, and those who are a danger to themselves or others. And of course, Republicans won't tell you that this is part of a broader effort to make all firearms and firearms accessories widely available without a background check, no matter how much it endangers all of us. In 2017, a shooter killed 60 people and injured more than 800 when he fired more than 1,000 rounds in just 10 minutes in Las Vegas, Nevada. He was able to fire so many rounds so quickly because they used firearms equipped with bump stocks. Earlier this year, the Supreme Court, stacked with Republican appointees, struck down the ATF's rule on bump stocks, allowing the accessory used in the deadliest mass shooting in U.S. history to be available once again to the public without even a background check. 9 Republican senators filed an amicus brief urging this result, and the decision was cheered by Republicans throughout Congress. There are bills in the House and Senate today that could be passed today to ban these devices, which make a firearm as deadly as a machine gun. These bills have overwhelming support from Democrats, but Republicans are blocking them in both chambers. Our Republican colleagues are again making the choice to keep the tool of the deadliest mass shooter in U.S. history easily accessible to the next mass shooters without any background check, without any age limit, and without any kind of restriction at all. And while our Republican colleagues choose to pursue legislation like this resolution to put more guns in the hands of dangerous people, Democrats will continue to choose to fight for laws that save lives. I urge my colleagues to join me once again in opposing this dangerous legislation, and I yield back the balance of my time.
Without objection, all other opening statements will be included in the record. Who seeks recognition? Mr. Ruley?
Thank you, Chairman. I yield my time back to the member from Kentucky.
I thank you, Mr. Ruley. I'd like to point out that in this Congressional Review Act, what we want to do is to basically nullify the rule that the ATF has proposed here. But there's one interesting statement in this ATF rule that I want to point out to everybody who's watching this, because the Democrats are always talking about a gun show loophole. Well, Biden's own Department of Justice in this rule says, the department also notes that the term gun show loophole is a misnomer and that there is no statutory exemption under the Gun Control Act for unlicensed persons to engage in the business of dealing in firearms at a gun show or at any other venue. I would hope that when Biden's own ATF quotes Biden's own DOJ that there is no gun show loophole, that this is a lie that's repeated over and over in the media, that maybe my colleagues on the other side of the aisle would pay attention. I also want to draw attention to something else that's going on with respect to this ATF rule. There's already an injunction against it. It didn't take long for this to happen because it's unconstitutional and illegal. The ATF has overstepped its bounds, and a judge has rightly called them out on it. And so there's an injunction. There are 4 specific faults, according to this judge, with the ATF's rule. Number 1, ATF falsely asserts that there is no minimum number of firearms to actually be sold, to be engaged in the business for the purposes of the licensing requirement. A single firearm transaction, or even a mere offer to engage in a transaction, may suffice. You know, when this rule came out, I was actually kind of hopeful that we would get some black and white definitions of who is a gun dealer, who is engaged in the business of dealing in guns, and who is not. Like maybe a numerical, threshold. If you sell more than, let's say, 12 guns in a year or 12 guns in a month, you would be a dealer. Or if you sell less than, let's say, 6 guns in a year, you would clearly not be a dealer. But there's no such threshold placed in here. In fact, The ATF introduces more gray area by saying that you could be a gun dealer without ever selling a gun. That's not going to make it easier to figure out who's a gun dealer and who's not and who needs a license. The second thing that the judge said in this injunction is that ATF falsely suggests that actual profit is not a requirement of the statute. It is only the predominant intent to earn a profit through the repetitive purchase and resale of firearms that is required. In other words, a person may repeatedly advertise and display firearms for sale and therefore demonstrate a predominant intent to earn a profit from repeatedly reselling the firearms purchase, but never actually find a buyer. So you could be a gun dealer without even having a buyer. So that's the second reason why the judge issued an injunction against this rule. The third reason, ATF arbitrarily eviscerates Section 921A21C's safe harbor provision. Nothing in the foregoing text suggests that the term, quote, personal collection, unquote, does not include firearms accumulated primarily for personal protection. Yet that is exactly what the final rule asserts. Fourth, and the judge has it absolutely right here. I'd like for somebody to tell me where the judge is wrong on his fourth assertion why this rule needed to be enjoined. But he says that the ATF has flipped the statute on its head by requiring that firearm owners prove innocence rather than the government prove guilt. This is like some dystopian future where everybody is guilty unless they can prove they're innocent. This rule is horrible. The judge has recognized that it needs to be thrown out, at least an injunction against it. And here today, we're recognizing congressionally that the ATF has overstepped its lawmaking authority by issuing a rule where they're basically trying to make laws and using as their basis laws that don't exist or laws that don't give them the authority that they claim they have.
Mr. Chairman?
Yes. Gentleman is...
I must just quickly make a correction to something I said in my opening statement. I said that the Bipartisan Safer Communities Act passed last year. In fact, it passed 2 years ago when the Democrats controlled both houses.
All right. Thank you very much. And with that, I will yield back. Who else seeks recognition? Ms. McBath from Georgia is recognized for 5 minutes.
Thank you so much, Mr. Chairman. The background check system, we know, is definitely a proven way to stop those who legally should not have guns, stop them from having them, and this system is relied upon daily by more than 130,000 federally licensed firearm sellers, many of whom are small business owners who abide by the law. And these licensed sellers run background checks and are the first line of defense in keeping guns out of the wrong hands. But for far too long, when someone knew that they couldn't get a gun from one of these sellers because they would fail the background check, they had many places to turn. They could turn to the internet, the right booth at a gun show, an acquaintance of an acquaintance who they could get a firearm that they wanted, and they could get it without even asking any questions. That's why Congress came together and we passed the Bipartisan Safer Communities Act, the most historic legislation that really takes steps in reducing gun violence in this country. And this legislation meant that the ATF had to issue a new rule to determine who is engaged in the business of selling firearms. This rule protects our communities, decreases criminal activity, and supports law enforcement by making gun purchases harder for bad actors looking to circumvent our gun laws and buy guns when they are prohibited from having one. Gun sellers should be our partners in upholding the law, and they should be taking steps to ensure that they are not placing firearms in the hands of criminals. Many gun sellers are doing just that, following the law, maintaining proper records, and conducting background checks. And under this rule, all gun sellers will be held to the same standard, whether they own a brick and mortar store or whether they sell online or sell at special events, so long as they do so to earn a profit. Now, our law enforcement leaders, they know that the updated rule definitely does decrease gun violence and reduces crime, because statistics are showing that. And that weakening the engaged in business definition with the resolution before us today would make all of us less safe. That's why Police Leaders for Community Safety opposes this dangerous legislation. As this letter that I have from Police Leaders for Community Safety explains, the ATF rule, and I quote, accommodates new forms of commerce and enhances public safety and should stand as written, end quote. Gun owners also support the bipartisan Safer Communities Act and oppose the dangerous resolution before us here today. Giffords Gun Owners for Safety is a coalition of gun owners from across the country who know that responsible gun ownership and sensible gun laws can and they do coexist. They write that background checks, and I quote, are among the most foundational of the policies that keep our communities safer, and that ensuring that people who are dealing in firearms as a business practice are appropriately licensed and conduct background checks, and that's critical, end quote. This resolution would weaken that law, reopen the black market, and only benefit those that are seeking to do harm or profit from gun violence. And I stand with law enforcement leaders, responsible gun owners, and every American fighting for a safer community, and I oppose this resolution. So I ask unanimous consent to submit to the record this letter from Police Leaders for Community Safety.
Without objection.
And I also ask unanimous consent to submit to the record here this letter from Giffords Gun Owners for Safety.
Without objection.
Well, thank you very much, Chairman, and I yield back.
Who seeks recognition?
Mr. Chairman.
The gentleman from Arizona is recognized.
Move strike the last word.
Gentleman is recognized.
Thank you. I'm going to yield time to you, Mr. Chairman.
Thank the gentleman from Arizona. Just want to address a few things that were just said on the other side of the aisle, that there's a requirement to make a profit in order to be a gun dealer. That is actually not the case. If you know, even a judge has recognized that this rule is so poorly written, or maybe it's written this way on purpose, that somebody just by merely advertising a gun could be declared to be a gun dealer if they didn't have a license at the time, whether they even had a buyer to purchase the firearm or not. So, you know, I just wanted to point that out, and that's as has been pointed out by the court. The other assumption or supposition that was made on the other side of the aisle here recently is that this would roll back something, that we would go back into some black market situation that previously existed. Well, the reality is, for many people, because of this injunction, this rule is not in place. Like, it's not like we're rolling it back. This rule has been enjoined by a court. So if you're in Louisiana or Mississippi or Utah or Texas, or you belong to GOA, which are probably 1 million people in that, or members of the Tennessee Firearms Association or Virginia Citizens Defense League, this rule doesn't apply to you. And because it's never effectively gone into place, because it was enjoined in a court of law. So it's not like anything that's in place would be rolled back. It would be taking a defective rule off of the books. And with that, I'll yield back to the gentleman from Arizona.
Thank you, Mr. Chairman. I'll yield.
The gentleman yields back. Who else seeks recognition? Ms. Scanlon is Ms. Dean is recognized for 5 minutes.
That happens to us. Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
God forbid we do anything to make our kids safe. I rise in opposition to H.J. Res. 144. 2 years ago, a Democratic majority in Congress, we passed the first meaningful gun violence prevention legislation in decades, the Bipartisan Safer Communities Act. In May of this year, ATF issued a rule to implement that hard-won progress. The rule helps gun sellers know how to act responsibly and legally. Specifically, it helps clarify when they need an FFL license and when they need to run a background check, something as simple as that. Simply put, the rule helps save lives. Do you know, gentlemen and ladies in the majority in this Judiciary Committee, already the Bipartisan Safer Communities Act enhanced background checks for people under 21 who were trying to obtain a long gun, a rifle, high-powered rifles often, and it has already prevented 800 sales to prohibited purchasers. 800. But we cannot let up, because today gun deaths are still the #1 killer of American children. Let me repeat that grotesque statistic. Today, gun deaths are the #1 killer of our children. Today, we're just weeks away from another deadly school shooting, resulting in the murder of 2 students and 2 educators at Appalachia High School in Georgia. Christian Angulo, who had a talent for making others laugh. Mason Schermerhorn, whose favorite color was red. Richard Aspen, who went by Coach A. Christina Ermy, who taught both dance and algebra. Today is just days away from a second assassination attempt on the former President Donald Trump, a tragic case in which the suspect, who was carrying a high-powered rifle, appears to also be a prohibited purchaser. And today, my Republican colleagues want to take big steps backwards. Do you not hear the cries of our constituents? Do you not hear the cries of mothers and fathers losing children, using young adults? Do you not hear the cries of children bleeding out in their own classrooms? Repealing the ATF rule makes the law less clear and each one of us, our families, our children, our friends, less safe. I implore my Republican colleagues to set aside this resolution and put our children's lives, American lives, first. I yield back.
Gentlelady yields back. Who else seeks recognition? Gentleman from California is recognized.
When it comes to gun violence policy, you're either for our kids or you're for their killers. This rule would undo violent history checks that protect our kids. Violent history checks, making sure that the most violent people don't have access to the most violent weapons. I have to ask my colleagues, do you talk to the people who you represent? Do you listen to their concerns? Who is asking for this? Who is asking for us to make it easier for the most dangerous weapons to end up in the hands of the most dangerous people? Are kids who are hiding under their desks in fear of gun violence asking for this? Are parents who are burying their children because guns are the #1 killer of kids in America, are they asking for this? Say you only talk to Republicans and you only talk to gun owners. Are Republican gun owners asking for this? I will tell you the answer to that one. No. Republican gun owners do not want this. In fact, a nonpartisan organization called 97% surveyed thousands of Republican gun owners, and they found as a nonpartisan organization that 78% of Republican gun owners want violent history checks. Okay. This legislation clearly is not looking out for our kids. Are you looking out for your presidential candidate? Because the guy has now had 2 assassination attempts on his life. And in both instances, the sick individuals who wanted to take his life were armed to the teeth with an assault rifle. Now, I would like to think that I serve in this distinguished body with smart people. Because smart people would be able to connect the dots that if you are very concerned about political violence in America, and maybe you're only concerned about the violence against your own candidate, which is only the time I ever hear many of you ever speak out, if you're concerned about violence against the former president, wouldn't you want to do something to stop gun dealers from selling weapons that could harm that person? You can't, out of one side of your mouth, ask, why are so many people shooting at the former president, and then out of the other side of your mouth, have a hearing and say, let's do everything to make it easier for somebody to shoot at the former president. We have a very serious assassination task force that has been set up to look at how we protect political candidates. I wish they were sitting here right now, because they would probably think it's insane that we're doing more to put guns on the street in a very toxic, amped up political environment, rather than doing more to protect those who are seeking public office. So this legislation doesn't protect our kids, doesn't protect our candidates. So I go back to, who is asking for this? Talk to your constituents. Talk to the people in our community who are affected by this policy. Talk to teachers. I talked to a substitute teacher recently, and I thought I'd heard every awful story about gun violence, because this job puts you in front of so many victims and their families. But a substitute teacher recently told me that more and more, as she comes into a classroom as a substitute teacher, the first thing her children are asking her is, do you know where to put us? And she said the first time she was asked this, she didn't know what the student was talking about. She said, what do you mean, where do I put you? And the child said, well, our teacher's not here. She knows where we go if there's a shooting, but you're the substitute. Do you know where we're supposed to go? This legislation only makes more kids fear for that, not fewer. So let's, for once, stand up for the kids and not their killers. And I yield back.
Gentleman yields back. Who else seeks recognition? The gentleman from New Jersey is recognized for 5 minutes.
Thank you, Chairman. I don't want to belabor this, and my friend from California is a good speaker and he's smooth, but let's really get down to what the issues are here. Horrible things happen, and they can happen with guns. And the response that so often is given and done is we put even more prohibitions and put actually legal gun owners who are doing nothing wrong in danger of making the slightest mistake. And by slightest mistake, I don't mean doing any harm to anybody, but all the technicalities that go along. And I am a gun owner, and I follow this stuff really carefully. It's so interesting. For example, there'll be a horrible incident, and everybody feels awful when this happens, but I want to talk about that in a minute. Horrible incident happens, so we reduce the magazine size that legal, registered gun owners can have. So what happens there is, I guess, that when somebody's going to go out and commit a murder, they make sure that they have magazines that are smaller. I'm being facetious. Obviously, they don't. They're breaking the law. All of these cases you bring up, they're breaking the current law. So we either have issues where there are sincere mental health issues and these people shouldn't have had the gun to begin with, and in almost all of these cases that you hear about, that you see, all these terrible tragedies, something should have happened a long time before the tragedy occurred under current law. But we put new laws in place, and we make them trickier and more complex to follow, where innocent people get in trouble that aren't doing anything wrong at all. But at the same hand, we hear all the concern and all the worry, but in our cities, we let repeated offenders, violent offenders, out on the street over and over and over again. And we've had those hearings. We've gone to Philadelphia, we've gone to New York, and we see what liberal prosecutors do. And they let these people back out in the street. Some of them have many as 14 offenses, and they finally kill somebody, but they shouldn't have had the opportunity to do that. So they kill somebody, and then we pass another law on a legal gun owner who's never done anybody any harm ever in their life. It doesn't make sense, and it doesn't work. We need to enforce the laws we have better. We need to ensure that mental health issues are dealt with properly. And then we get to this piece of legislation, which is vaguely written, and again would have the same effect of hurting somebody that really doesn't deserve it. You know, I remember in the state of New Jersey a number of years back, there was a young woman, African-American, single mom, had never had anything, never had done anything wrong in her life, and lives in Pennsylvania, lived in Philadelphia. She crossed the bridge and didn't realize that when she had a carry permit, a legal carry permit. When she crossed over into New Jersey, even though she never had a prior, never did anything wrong, had a legal permit in Pennsylvania, crossed over to New Jersey over the bridge and was stopped for some sort of a traffic infraction, she informed the police officer, just so you know, I have a right to carry and I am carrying in the vehicle. They put her in jail for 3 years. A woman who never did any harm. Fortunately, the governor at the time got her out earlier than that. Putting that good woman in jail for a minor mistake because of a vaguely written law didn't help anybody. It didn't prevent any murder. It didn't prevent any horror. It just hurt a good person. Guess what? That happens all over. One of the things you learn about when you go and if you carry, and if you are a gun owner, you will find out how very careful you must be because you're legal and you're registered and you're trying to do everything right because you're the one that's going to get in trouble. That's the case here. We don't need another law. We need to enforce the laws we have. We need mental health to be dealt with. We need to make sure that these people who have set up all kinds of should have been red flags in all the cases that you mentioned, they shouldn't have had guns. But somehow, even though the FBI had interviewed them, somehow when teachers had complained about them, somehow when neighbors had said there was something wrong, nothing happened. Creating harsher laws on legal gun owners is still not going to fix it. So I guess the lesson learned here is, you know, it's great politics and it's simplistic politics to say, yes, let's really crack down on people who've never done harm more but happen to be a gun owner, but at the same time let people back out on the street in the inner cities or not deal with the people who are obviously dangerous. I say let's enforce the current laws and make sure that we're doing everything as we should, and then you'll finally get something done. What happened, this legislation, let me put it this way, just make sure that innocent people don't get hurt. I yield back.
The gentleman yields back. The gentlelady from Pennsylvania is now recognized for 5 minutes.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Okay. Look, too many Americans have been scarred by gun violence, and our communities have lost too many children, too many parents, too many neighbors, teachers, police officers, and loved ones. Last week, one of my constituents, a track coach, asked me why Congress wasn't doing more to protect the kids on his high school team and to protect his daughter, who's also a teacher. Because with the start of a new school year, we've seen the start of new school year shootings. Look, 2 years ago, Congress passed the Bipartisan Safer Communities Act, the first significant gun safety legislation signed into law in decades. That law, among other things, made a long-needed change to the definition of engaged in the business of firearms to close dangerous loopholes in our background check system and ensure that guns are kept out of the hands of those that we all know shouldn't have them. It's a common-sense provision to eliminate known dangers. The rule that the ATF finalized this past April is necessary to ensure that that provision in the Bipartisan Safer Communities Act is being implemented and enforced effectively. But with this resolution, it's clear that once again our Republican colleagues want to make it easier for bad actors to evade this common sense gun safety protection and to attack the ATF, the law enforcement agency tasked with enforcing gun safety laws across the country. And it has to be noted and emphasized that voting for this resolution will prevent ATF from issuing further regulations in this space. So we know that gun violence is not inevitable. It's enabled, though, by lawmakers who choose to do nothing in the wake of tragedy after tragedy, and even to undermine the limited gun safety legislation which we have managed to pass. So those who want to champion the dangerous ideas laid out in Project 2025 that would kneecap the ATF and prevent the agency from being able to enforce laws already on the books should be ashamed of themselves. Background checks save lives. This rule will save lives. Americans are crying out for action, and we can't go backwards. I deeply oppose this resolution, and I yield back.
The gentlelady yields back. The gentleman from Alabama is now recognized for 5 minutes.
Thank you, Mr. Chairman. I'll yield 5 to you, sir.
I thank the gentleman. There are a couple facts here that I want to expand on, or misstatements that aren't, in fact, truthful. First of all, even though it's not material to the debate today, the other side of the aisle felt inclined to say that the second assassination attempt on President Trump was done with an assault rifle. The problem with that assertion is that the rifle that was used doesn't have the features, the cosmetic features that the Democrats have used in their legislation to define an assault rifle. Because the reality is, their hunting rifles are every bit, and in some cases, depending on the caliber, more deadly, but every bit as deadly as what the Democrats call an assault rifle. And for instance, the rifle that was used in the attempted assassination of Trump did not have a pistol grip, did not have a foregrip, did not have a collapsible stock. So this points out the futility of the legislation on the other side of the aisle, or maybe what it points out is actually their true intention, which is that they don't want to ban just what they call assault rifles. They want to ban virtually every rifle. Any rifle, for instance, with a detachable magazine. Now, the rifle that was used, fortunately was not used, but could have been used in that second assassination attempt, had been originally designed to not even have a detachable magazine. You can modify firearms to have detachable magazines, but no law is going to stop you from selling that firearm, and especially the laws that the Democrats have proposed. So even though we're not discussing today an assault weapons ban, I felt it was important to refute one of the misstatements from the other side of the aisle that it was an assault weapon that was used in the second assassination attempt. Doesn't meet the definition. The other thing that I wanted to refute here is I heard that there were 800 sales to prohibited purchasers that were prevented. I don't know what span of time that was supposedly within, but that was a statement from the other side of the aisle. My question is, why were there not 800 commensurate prosecutions of people who prohibited people who tried to purchase a firearm? Because the way it's illegal to try to purchase a firearm if you're a prohibited person. In fact, you would have to lie on a government form for them to accept that form and run a background check on you. It's only when they run the check that they find out that you have lied. Why are we not prosecuting these people? In fact, there's a DOJ study, the most recent one that I've been able to find, that said there were actually 112,000 denials in a given year. But there were only 12 prosecutions, 12 federal prosecutions out of 100,000 firearms denials. Now, the reality is a lot of those denials are false denials, where people who are, law-abiding citizens were deprived of the right to purchase a firearm. And that's why some of them aren't prosecuted, but I wonder why the other ones aren't prosecuted. And with that, I'll yield back to the gentleman from Alabama.
Thank you, Chairman. I yield back.
The gentleman yields back. Mr. Ivey is now recognized for his 5 minutes.
Thank you, Mr. Chairman. It's hard to know where to start on this one. I did want to address a couple of points. One that you just made, actually, with respect to the attempt in Florida, and your point about it's not actually an assault weapon. It is an AR-style weapon. I don't think there's any dispute about that. But what caught my attention about it, as a member of the task force, is that the person that had the weapon had a prior record of, one was, I think it was called a weapon of mass destruction in North Carolina, if I recall correctly. And he had other offenses too. So my first thought when I saw that was, how did he get his hands on this? So we can debate the ins and outs of it, I suppose, but I think the bottom line is people are getting their hands on guns who shouldn't be getting them. And my friend from New Jersey, I think, you know, sort of, my colleagues, and look, I'm not imputing bad faith to you, but you go to the mental health thing and enforce the laws arguments. And so here's the challenge, especially on the enforce the laws part. A lot of the shooters we're seeing these days, including the one in Butler, didn't have prior criminal records. So anything about, you know, it's lax bail or, you know, these Democratic prosecutors are turning them loose, and none of that applies to most of these cases. If you look back at these recent school shootings, especially when they're like juveniles, they don't have prior records. They haven't been released on bail. Many of them don't even live in districts that are blue districts. So we know that's not a way to address this problem. And then the mental health piece, again, the shooter in Butler, and it's true for many of these, there are no findings of mental health issues. Now, we go back and we say, well, there's a red flag, he was missing school a lot or something like that. But if they started denying guns to people based on those kinds of things, you guys, we'd have to peel you off the ceiling for it, right? So we know that those two things aren't going to address these problems. Now, one of the things we're trying to do with this particular provision is to reduce the number of sales that are being done illegally, at least under this provision, that result in violence down the road. Columbine was, I guess, one of the first where this took place. You know, 12 were killed, 1 teacher. Shooters used guns that were purchased from unlicensed sellers at a gun show without background checks. I mean, I think that's something that we should be trying to fix. You know, all 6 of my adult children live in the DC area. And on Sundays, sometimes they come by, and one day I walked up and my 12-year-old granddaughter was debating with her 8-year-old cousin, and they were very passionate about it. And I said, well, what are you guys arguing about? And they said, we're having a disagreement about what to do when an active shooter shows up at your school. How do you respond? And it really kind of stuns me. I mean, I was a kid going to school, we had fire drills. Now they have active shooter drills, as my colleague from California mentioned a minute ago. Isn't that a problem for you? I mean, don't you see that the challenges we're facing, the things we're putting our kids through in school, they're going to school and they're not just thinking about how to, you know, how I can pass this test or did I get my homework done. They're trying to figure out what to do when the shooter shows up and where to hide in the classroom. And if their substitute teacher knows what to do when the shooting takes place. I can't believe we're satisfied with that status quo, because we know that mental health, bail, all that stuff you guys talk about doesn't address these problems. And I'll make the request again. We had this discussion a year and a half ago in this very hearing room. I said, look, I'll work with any of you guys on trying to find ways to address these problems. We've got bills on the Democratic side to ban ghost guns. Who could be in favor of ghost guns? They're illegal because they can't be traced. In fact, they're made so that law enforcement can't track down the people that use them. Not one Republican co-sponsor for that legislation. I had one of my own. Let's raise the age up for people who want to use assault-style weapons. Let's raise it from 18 to 21. It's already 21 for handguns. Can't we raise it for this? 150 plus Democrats co-sponsor, 0 Republicans. And, you know, if you've got a dispute with the bill, let me know. Because, again, I'd love to see if we could reach some sort of bipartisan accommodation to address some of these issues. Let's at least make progress on trying to keep our kids from being scared when they go to school. We can respect the Second Amendment and also protect our second graders. And with that, I yield back.
The gentleman yields back. The gentleman from Georgia is now recognized for 5 minutes.
Thank you, Mr. Chairman. I'm afraid that HJ Res 144 is another page straight out of Project 2025, the playbook for 2025, should the country be so unfortunate as to witness the ascension of Donald Trump again to the White House. And my friends today on the other side of the aisle are doing some advance work on Project 2025. That's why we're bringing this bill forward. It attempts to undo a reasonable regulation that has been issued by ATF to keep Americans safe. The definition of what a handgun dealer or what a firearms dealer is just common sense, but this, pursuant to Project 2025, would seek to just undo what the ATF has done to keep us safe. And so I oppose the resolution. You know, my friends on the other side of the aisle, including Donald Trump, are trying to run away from Project 2025, but what it would do would be to politicize law enforcement in the independence of the United States Department of Justice, and it would actually move the Bureau of Alcohol, Tobacco, and Firearms and Explosives from the FBI and put it in the Treasury Department, which would undermine law enforcement efforts to reduce violent crime. I mean, we witnessed last week another school shooting. 2 students and 2 teachers killed in a high school in Winder, Georgia, not very far from the district that I represent. It hits home, and it will continue to hit home as we continue to be promiscuous in our allowance of guns in the hands of everyone, whatever kind of gun they want, throughout America. It's been a long time developing, but it's gotten to the point where we're now saturated with assault weapons, assault look-alike weapons that kill, just like assault weapons. However you want to split the baby, you know, the same impact is there, killing people, harming people, children, innocent children trying to go to school. So I don't know why we're trying to make it even easier for people to deal in these firearms. You go to a gun show at in any state on any given weekend, you'll see licensed gun dealers having to run background checks on purchasers at the gun show, right beside a table of an unlicensed gun dealer who does not have to run background checks. They each have the same merchandise. Sometimes the unlicensed gun dealer has the licensed gun dealer blushing because they've got more wares on the table than the licensed gun dealer does, and more powerful weapons. And so people are flocking to those unlicensed gun dealers like flies. They're lighting on them and purchasing their wares and going back and selling those wares to others or using those wares to commit crimes. It's not just people wanting to defend themselves, it's people wanting to perpetrate crime. That's why it's so reckless for the gun lobby and those who support them to continue to want to keep the floodgates open, making us less and less safe the more and more guns that are on the street. I don't think it can be argued any longer that that the remedy for a wrongdoer with a gun is a good guy with a gun. That just does not work. It's a race to the bottom. We need to cut this reliance on the on the financial capital of the National Rifle Association. We need to cut that string where they're dictating policy, dictating into Project 2025 what policies we should have as a government and as a people. It does not work. It has not worked. It's resulted in crime. It's resulted in killing and maiming. And it's time for us to end the bloodletting, and we can partially do that by voting no on HRES 144, and with that, I yield back.
The gentleman yields back, and I'll recognize the gentleman from California for 5 minutes.
Thank you, Mr. Chairman. I don't know of any other way to stop a bad guy with a gun than with a good guy with a gun. The only question is how long it takes. As that bit of wisdom says, in such a situation, the police can be there in minutes when seconds count. I yield the balance of my time to the gentleman from Kentucky.
I think the gentleman from California. The gentleman on the other side of the aisle just described this apocryphal situation that doesn't really exist. And even the ATF and the DOJ and this rule say that situation doesn't exist. You don't have people with giant tables of guns with customers lighting on them like flies, as the gentleman suggests, selling guns at a gun show without background checks. Because what happens at these gun shows, you got ATF agents at the gun shows. Nobody sets up and engages in illegal dealing of guns without an FFL. It just doesn't happen. Somebody may display part of a private collection there, but they're not selling guns en masse. In fact, there's already a definition of a gun dealer in the statutes. And if somebody were to do what was just described on the other side of the aisle, they would be convicted. They would be convicted. People, and they know that. And they know there are ATF agents at the gun shows and say they don't do this. And I just want to read again from the Federal Register. This is the ATF's rule that we're debating here today. And they're quoting the Department of Justice here. They say the department also notes that the term gun show loophole is a misnomer and that there is no statutory exemption under the GCA, that stands for Gun Control Act, 1968, for unlicensed persons to engage in the business of dealing in firearms at a gun show or at any other venue. It can't happen, doesn't happen. If it does, there's going to be a prosecution, and people know that, so they just don't engage in it. So it's just a fantasy that keeps getting described over and over again that I could hope that this rule that the Democrats are defending so strongly, they need to read it.
Would the gentleman yield?
And look. Yeah, has the gentleman been to a gun show and bought one of these guns?
I've been to a number of them, in Georgia and in Tennessee, and I see the same thing at all of these gun shows. I go, put my cap on, sometimes I'll put a fake beard on, and they still recognize me.
Are they like, is that guy that thought Guam was going to tip over?
Well, I mean, yeah, I mean, gosh, Guam is just an old story. Everybody knows that was a joke, and you do also. But it does not. It does not reclaim my time. Well,
I'm going to reclaim my time.
You didn't let me make my point.
The gentleman had plenty of time, and you got plenty of time on that side of the aisle. And by the way, it's the gentleman from California's time. Reclaiming my time. This rule says that there is no gun show loophole. The DOJ has said that. And so I would submit it for the record, but this is actually the material that we are debating today.
Truth is truth, and reality is reality.
Okay.
And you Trumpers
unless you're on Guam,
to ignore reality,
in which reality can be distorted.
Well, your reality
if
is
enough
right
troops
here
are placed on one side of the island,
reality deadly.
Gets shaky.
Your reality is
it
very
could capsize. All right, reclaiming the gentleman's time that he yielded to me. The rule here says that there is no gun show loophole. And that's from Biden's DOJ, and it's being quoted by the ATF here in this statement.
Gun show loophole.
Now, the ATF could have done a service. They really could have done a service in this rule.
Everybody
they could
knows
have
that
set
that's the
they could have set
reality
a threshold for the number of firearms sold, and maybe the other side of the aisle would support that. Like, why didn't they pick a number and say, if you're selling more than 6 guns in a month or 6 guns in a year, we can debate the number, then you are probably or may be a gun dealer, or you are automatically a gun dealer if you sell more than 1 a month. They could have said that. They didn't say that. They could have said if you sell less than 1 a month, there's a safe harbor and you're not a gun dealer. But they chose not to do that. In fact, they created a gray area. They had an opportunity to protect our citizens, and I think probably could have made the Democrats happy if they had put thresholds in here. But that's not what they want. They want a gray area so they can prosecute people, so that they can break down your door because you ran an ad to sell a gun, even if you didn't sell a gun. Maybe it was out of your personal collection. And I would love for this to be a hypothetical, but it's actual cases that happen. So we need resolution on what is a gun dealer. This rule does not provide it. in any way. It just makes it more of a gray area. And now I yield back to myself, or yield to the gentleman from California whose time has expired, and I recognize Ms. Ballant from Vermont for 5 minutes.
Thank you, Mr. Chair. I do not support this resolution that the majority has brought. The American people, my constituents, want us desperately to do something to reduce the incidence of horrible gun violence. And every time I'm back home in Vermont, and Vermont is a state that has a lot of gun owners. We have a strong and long hunting culture. And whenever I'm back home, people ask me, I don't understand why you can't pass reasonable gun violence prevention measures. Parents ask me, teachers ask me, kids ask me. I'm a former teacher, talk to a lot of students. Say, I don't understand why this is so difficult. And I want to tell you, I sit in this committee and I think, what is the best way that I can give voice to my constituents back home? Because I get to be in this committee and here on Capitol Hill, and I am the avenue through which their voices can get brought into this, this conversation. I want to tell you, what I'm hearing is that parents used to be excited about a new school year. I know I used to be excited about a new school year. I've got 2 teenagers. They both go to the local high school. And when school started just a couple weeks ago, had to have a conversation with my wife because the school is cracking down and making sure that the kids are not opening their phones in school, which I support. But we also had to have a conversation. Well, so what are we going to say to our kids? We're going to tell our kids, yeah, respect the rules, but keep your phones close by. Because if something happens, if a shooter comes into the building, we want you to be able to get in touch with us. And why is that? Because every parent's worst fear is that they're not going to be able to talk to their kid when they're under fire. And so when we sit in here and we talk in sort of nitpicking theoretical terms, it's all small potatoes, because what the American people want is for us to actually do something. I want to associate myself with the remarks of my colleague from Maryland. He talked about, why is it that we aren't taking on ghost guns? Why are we not dealing with purchasing age for these assault weapons? Why is it that we can't have a substantive conversation about the fact that we seem to love our guns more in this country than we do our own children? I thought for sure, as a teacher, that something would change after what happened in Connecticut in Newtown. I was sure of it. How could we as a nation see 5- and 6-year-olds slaughtered, and then it's just sort of a shrug from elected officials? And since then, of course, we've had again and again and again these horrible instances. One of the last years, because I used to be a classroom teacher, one of the last years I taught, they cut down all of the bushes in front of the school because they didn't want there to be any places for shooters to be able to hide, to get off a shot into the classrooms. What we are living with, what Americans are living with right now, is sick. It's disgusting. And we twiddle our thumbs and say, well, there's nothing that we can do. Well, there are evil people in the world. Of course there are. And we are the elected officials who were sent here to actually do something so that people could live a life of freedom in this country. It is not feeling like freedom when you are afraid to send your children to school at the beginning of the school year. So I look forward to a time in this committee and hopefully in the next Congress when we can roll up our sleeves and actually do something to reduce the horrible scourge of gun violence in this country, because that is what our constituents overwhelmingly want us to do. I yield back.
Generally yields back. The gentleman from Oregon is now recognized for 5 minutes.
Thank you, Mr. Chair. I yield to the gentleman, Mr. Van Drew.
I thank the gentleman from Oregon, and I just want to address something the gentlelady from Vermont said. It's interesting because you speak about where you come from, you speak about Vermont, just so folks know who are listening or watching this, you do not even need a permit to carry in the state of Vermont. Residents or visitors don't even need a permit to carry. So maybe before we put more onerous and unbelievably difficult rules and laws in that are vague and again could hurt good people who are obeying the law, sometimes you have to look internally to see what's going on in your own area. I yield to the chairman. I don't know if you had anything else to say, Chairman. Then I yield back.
The gentleman yields
I yield
back.
back to you. I'm sorry. I couldn't yield to the
Gentleman yields back to the gentleman from Oregon. The gentleman yields back. And now recognize Ms. Ross from North Carolina for 5 minutes.
Thank you very much. I just want to remind people that the Bipartisan Safer Communities Act was called the Bipartisan Safer Communities Act because Republican senators voted for it, including both of the Republican senators from North Carolina, largely because they were concerned about illegal gun sales that went through a pipeline on I-95 that goes through North Carolina. And I don't think that's a small thing for both of our Republican senators to have done it. And I commend one of them, Richard Burr, has now retired, but I commend both of them for having done it. I want to yield the balance of my time to my colleague from Vermont.
While it's true that if you are a lawful citizen in good standing, that you can have, you may carry openly, you can have a concealed gun in Vermont. We have plenty of gun safety laws on the books, many of which I was instrumental in helping to pass when I was in the legislature. You must be 21 to purchase a firearm. You have to have background checks. You have to make sure your gun is in a safe and secure situation in your home. And so I think it's really important that we understand that in Vermont, we've been able to hold both things. That yes, people are entitled to their rights to carry a gun. And also, there are steps that we can take to keep our citizenry safe. Both things can be true at once. I yield back.
The gentlelady yields back. I just want to point out in my opening statement that Senator Tillis, who sponsored the bipartisan act that supposedly led to this, now opposes this rule. And does anyone else seek recognition? The question is on favorably reporting the resolution. All of those in favor say aye. Aye. Those opposed say no. The ayes have it, and the resolution is ordered to be reported favorably to the House. Members will have 2 days. A recorded vote is requested. The clerk will call the roll.
Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes aye. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Mr. Moran votes yes. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Rulli? Mr. Rulli votes aye. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? No. Ms. Ross votes no. Ms. Bush? Mr. Ivy? No. Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Mr. Nadler, you're not recorded. Mr. Nadler votes no. Mr. Fitzgerald votes yes. Ms. Escobar votes no. Mr. Klein votes yes.
One more member. While we're waiting, I just let the committee know we have one more bill that we think we can move through pretty expeditiously. And I know we got votes and stuff on the floor, including a bill from this committee. So we're going to try to go quickly if we can. I think we've had conversation with both with the minority staff and members. So I just need to get someone here.
Mr. Biggs? Mr. Biggs votes yes. Mr. Chairman, there are 14 ayes and 9 noes.
Views. Without objection, the bill will be reported as a single amendment in nature for substitute incorporating all adopted amendments, and staff is authorized to make technical conforming changes. Pursuant to notice, I call up H.R. 8419, the American Victims of Terrorism Compensation Act, for purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R.
Without
8419.
objection, the bill will be considered as read and open for amendment at any point. Before opening statements, I want to note that this bill was noticed pursuant to the authority in Committee Rule 2, Clause E, House Rule 11, Clause 2G, and with the consent of the ranking member. We thank him. We thank the ranking member for working with us to bring this important bill to markup. Chair now recognizes himself for a brief opening statement. In 2015, Congress created the United States Victims of State-Sponsored Terrorism Fund to enable U.S. persons with judgments against designated state sponsors of terrorism for acts of international terrorism to satisfy a portion of those judgments. State sponsors of terrorism include countries like Syria, Iran, North Korea, and Cuba. Because these countries do not keep assets in the United States, American victims of terrorism perpetrated by these countries previously had no way to recover on judgments awarded by U.S. courts. The victims who are eligible to participate in this fund include those held hostage in Tehran Embassy in 1979, victims of the Beirut and Nairobi embassy bombings, 9/11 victims, and others. The VSST fund is funded through proceeds of enforcement actions against those who violate sanctions laws like the International Emergency Economic Powers Act and Trading with the Enemy Act. Unfortunately, we have learned that utilizing just the proceeds of these enforcement actions does not provide enough revenue to result in meaningful distributions to victims. When Congress created the VSST fund, it was designed to make annual distributions to those with eligible judgments. However, the fund has made only 4 disbursements to date, despite almost a decade of passing since its creation. The American Victims of Terrorism Compensation Act would seek to remedy this shortfall by establishing new funding mechanisms for the VSST fund. First, the bill directs the deposit of the net proceeds of an enforcement action against Binance Holdings for violations of sanctions and other laws to the VSST fund. Second, the bill will require the deposit of half of the excess unobligated balances, and I'm going to stress that, excess unobligated balances remaining at the end of the fiscal year in the Department of Justice Asset Forfeiture Fund and the Treasury Asset Forfeiture Fund. So these unobligated balances are what remains after all operational expenses, equitable sharing payments, and other permissible uses under the law have been accounted for. So the money's there. We want to use it to help these victims of terrorism. Under current law, these unobligated balances serve as slush funds for the Attorney General and the Treasury Secretary. Third, the bill changes the way that sanctions enforcement case proceeds are directed into the fund. These changes are drafted carefully to ensure that asset forfeiture funds can continue to operate in their intended way and that victims continue to receive any court-ordered restitution that they are entitled to. These changes also ensure that taxpayer money is not used to pay judgments owed by those who engage in terrorism. I want to thank a number of our members. I want to thank Mr. Moran, who worked hard on the language to deal with these issues, as well as Congresswoman Lee and Ranking Member Nadler and his team as well, working with all those parties and, of course, the sponsor of the legislation. I urge members to support the bill, and I yield to the Ranking Member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, last week we observed the 23rd anniversary of the September 11th attacks, the deadliest terror attack ever on American soil. Sadly, 9/11 victims are not the only Americans who have suffered at the hands of international terrorists in recent decades. From the Beirut bombing victims to victims of the attack on the USS Cole, the embassy bombings in Kenya and Tanzania, victims of the Iranian hostage crisis, and many others. There is no way to truly make whole the victims of terrorism or the families of those who lost their lives. But our courts do allow them to obtain some small measure of justice in the form of civil damages against certain perpetrators. These judgments, however, mean very little if there is no way to collect on them, and not surprisingly, terrorists do not pay up. The U.S. Victims of State-Sponsored Terrorism Fund, or VSSTF, was created in 2015 to compensate the victims of acts of terrorism committed by designated state sponsors of terror and to provide some comfort and justice after all that they have endured. The VSSTF is funded almost entirely through the fines and penalties collected by DOJ in certain cases involving state sponsors of terror. Unfortunately, for a variety of reasons, the qualifying deposits into the fund have dwindled in recent years, and distributions from the fund have slowed to a trickle. It has made only 4 distributions over its 8-year existence, and the fund's special masters announced that no distribution will be made in 2024, with future payments uncertain. The American Victims of Terrorism Compensation Act would address this funding shortfall to ensure that the VSSTF is on solid footing going forward. This is especially important not just for the claimants currently in the fund, but also for new claimants that may arise, such as those who suffered from the horrific October 7th attacks in Israel. The bill would also ensure that distributions are made to victims each year and would inject some much-needed transparency over the fund. Mr. Chairman, although I support this legislation because it is essential that we support victims of terrorism and that we sustain the VSSTF for many years to come, I would note that concerns have been raised that this legislation might unintentionally divert funds away from the Crime Victims Fund, which is an important resource for other victims of crime, and which is also suffering a serious shortfall. I was proud to sponsor the VOCA fix to sustain the Crime Victims Fund Act of 2021, a law that took important steps to shore up the fund. But unfortunately, more funding is needed, and I am committed to working with stakeholders to see that the Crime Victims Fund has the necessary resources to support those in need. I understand that an amendment will be offered that makes a good faith effort to address these concerns. I will be pleased to support it, and I appreciate the Chairman's efforts to find a solution that is satisfactory to all the parties. To the extent that further changes may be needed to protect the Crime Victims Fund, however, I hope that today's markup will be only the beginning of a conversation about how best to protect all victims of crime, and that we can work together as this bill moves through the legislative process to ensure that it does not have any unintended consequences that might impact other victims. With that said, I support passage of the American Victims of Terrorism Compensation Act to ensure that victims of terror receive meaningful compensation for the losses they have suffered. I hope that these funds can provide some measure of comfort and justice to all those who continue to suffer the wounds left by acts of terror, and I urge all members to support the bill. I yield back.
Gentleman yields back. I have an amendment in the nature of a substitute at the desk. The clerk will report the amendment.
Amendment in the nature of
Without
a
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of the amendment. This amendment makes various changes to the bill incorporating the feedback and technical assistance of the Department of Justice, Appropriations Committee, and relevant stakeholders. These changes are intended to ensure that the amendments made by this bill operate correctly and achieve their purpose. I urge support for the amendment, and I yield back. The chair recognizes the gentleman from Texas.
Mr. Chairman, I have an amendment to the amendment in the nature of a substitute at the desk.
Clerk will report.
Amendment to the amendment in the nature.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Mr. Chairman, this amendment protects the purpose and integrity of the underlying bill, the American Victims Terrorism Compensation Act, while also protecting funds otherwise already dedicated to the Crime Victims Fund, which is established under Section 2101 of Title 34 of the United States Code. I appreciate the work of the committee staff on both sides of the aisle, Representative Wagner's office, Representative Lawler's office, and other stakeholders who sought to find language that would shore up the needed changes to the provisions of the Justice for United States Victims of State-Sponsored Terrorism Act so as to protect funding for victims of terrorism while also ensuring that such funding did not negatively impact victims of other crimes who benefit from existing funding of the Crime Victims Fund. Both groups certainly deserve appropriate support. This bill, with this amendment, strikes that balance and achieves that dual goal. I urge my colleagues to support this amendment to the amendment in the nature of the substitute and the underlying bill. I yield back.
Gentleman yields back. I appreciate the gentleman's work on this and all the stakeholders he talked about. The chair recognizes the ranking member.
Mr. Chairman, as I said in my opening statement, I appreciate the chairman's work on this amendment, and I urge all members to support it. I yield back.
Question, the gentleman yields. The question occurs on the amendment offered from the gentleman from Texas. All those in favor say the amendment to the amendment in the nature of a substitute. The question occurs on that. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The chair now recognizes, the amendment's adopted, the chair now recognizes the gentleman from New Jersey who is also working in this very important area with a piece of legislation that is very important as well. And I wanted to give him an opportunity to speak. So the gentleman from New Jersey is recognized for 5 minutes.
Thank you, Chairman. First of all, I'm not opposed to this bill, but I do want to utilize it as a vehicle to speak about just this entire issue. You know, it's 23 years since 9/11, and we said we would never forget. Sometimes I think we have. And we passed a bill years ago, years before I was in this Congress, JASTA, which finally would have given the victims of this terrible, horrible tragedy legal recourse. And unfortunately, the way that bill was drafted, there were some technical errors, and not even, I wouldn't call them errors, technical loopholes in it, so they never achieved that justice they were supposed to achieve. I filed a bill which is bipartisan. I thank the ranking member is on that bill with me, ensuring justice for the Victims of Terrorism Act. And I don't think I have to remind people of 9/11, but I'm gonna anyhow, because it seems to me in those 23 years that have passed, Americans, unfortunately, some have forgotten, some never knew. I don't think I have to review, though, the horror, the pain, the broken bodies, the broken souls, the death, the disfigurement, the agony that people went through. It was awful. I was a young man at the time. And you know, time has passed, but we look back on it, there was, unfortunately, in every tragedy, there can be some good. Americans came together, men and women, East Coast, West Coast, black, white, Asian, Hispanic, it didn't matter. We were all Americans. And something that this Congress and this Senate wanted to set right was that these victims would achieve that justice, that legal recompense. And so they passed that original bill. So we now have a bill, my bill, that ensuring justice for the Victim of Terrorism Act fixes the loopholes that are in there so that they can achieve that justice. My bill makes it right. It gives these men and women, these families, these tortured people, the recompense, some modicum of hope, justice, and final closure. It is the American way to do that. So I'm going to continue to press on for that. And I know there are powerful forces out there. I'm going to be very frank. There's powerful people like the Saudis. And the Saudis are great. And I hope that we reach another Abraham Accord, and we so desperately want them to be part of it. But in order to do it, we have to make things right and heal the wounds that exist out there. It won't stop the Abraham Accords if we pass the bill that gives these victims those rights. You know, originally, they said that the original JASTA bill, that it would everything would blow up if it passed. It did pass. It passed overwhelmingly in the House and in the Senate, and it was vetoed by President Obama. And in a bipartisan way, the veto was even overridden. So I maintain that the majority of members of this House and the majority by far of the members in the Senate want to do the right thing and get this done. So, Mr. Chairman, I'm just going to say this. I will never forget. I do not believe that you will ever forget. I don't believe that this body, either body, should ever forget. I care about what happens with the Saudis, but God help me, I care more about what happens to these American victims who lost their mothers, their fathers, their brothers, their sisters, their daughters, and their sons. It's about time we made it right. That's what Americans do in a bipartisan way. I won't give up. Mr. Chairman, I yield back.
Would the gentleman yield?
Yes, I will yield.
I just want to say I support Mr. Van Drew's legislation, and it's important. We've been fighting for years for this. It's an inconvenient truth, but Saudi Arabia was complicit in the attacks on 9/11. That is a fact. We know that for a fact. The government of Saudi Arabia. And like Mr. Van Drew, I know it's inconvenient. It's a difficult thing to discuss right now with the situation that we have around the world and in the Middle East, but these victims deserve justice. And whether the top officials of the Saudi Arabian government are complicit or not, it doesn't matter. Whether there was intent or not, they helped the hijackers pull off the hijack. The government of Saudi Arabia did. And we got JASTA passed. They deserve compensation. They deserve their day in court, and they're not getting it. And that's why I support Mr. Van Drew's legislation. And I yield back to the gentleman from New Jersey.
I thank you, and I yield back to the chairman.
I appreciate the gentleman, his work and his sincere efforts on this. And the question is on now the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. All those opposed, no. And pin the chair, the ayes have it. And the amendment in the nature The amended amendment in the nature of a substitute is adopted. The question is now on favorably reporting the bill as amended. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. I got one more thing to read. The ayes having the bills ordered to be reported in favor to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. And the committee is adjourned.